Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. I don't know what's happening with my thing. See? Good morning, everybody. Thank you so much for joining. I'm Ada K, and today we have Karen Reed drama. Karen Reed drama. Yes, we do. We have a lot of Karen Reed drama. Why am I having problems finding my little circle doohickey? Trying to find my circle doohickey. Anyway, thank you guys so much for being here today. We love and appreciate every single one of you. And it is going to be a crazy day. A crazy, crazy day. Seriously crazy day. I don't know why my camera is not cooperating with me. We have a guest with us all day today. Are you ready to welcome her? Let me get everything on stage. Welcome, Miss Angela. Oh, I like the background, my love.
Thank you.
I love
I'm at the university today, so that's why I have this beautiful background.
Oh, that is so pretty.
Yeah.
I like.
I just realized I have this shirt that says magical. Hopefully today will be magical.
I'm hoping today will be magical, but I don't have that much hope.
And me neither.
And I don't have my glasses on, guys, so if I look like I'm squinting a little. So last night I was in bed, and I really got bummed yesterday. I was gobsmacked yesterday over the fact that there was an announcement the day before this motion hearing, that there is going to be that the feds were not going to bring charges in this case. And I'm like, I find it interesting how the timing of all this information is dropping. And then also all of the court docs concerning the last motion hearing and how the defense didn't win a single motion hearing yesterday. They had some agreements in court with the prosecution, but every motion that was put forth, they really didn't win anything. And it just really put me on edge, so to speak.
Bev needs to go. Bev needs to go. Seriously, she is so biased. It's unreal.
Well, there is a petition out there that you can sign, but it's not going to get
1,700. What's the name? 1,700 people signed it. I was one of them. I was the first. I was like, as soon as I saw it, I was like, I'm signing it. Like, what they're gonna do to me too.
Signed it. It can't hurt. But the thing is I got to thinking, the feds normally do not, or would not normally. I don't know. It just didn't sound like a federal statement to me.
Have you seen what the lawyer Peter, aka lawyer said regarding it?
No.
I'm gonna read it to you.
Okay, and your voice is real soft, my dear.
Sorry, I'll try to pick it up a little.
Did you type it up, or is it a written comment on X or somewhere?
It's on X.
Okay, let me try and pull it up. And what is his thing in X? Lawyer,
lawyer, just lawyer,
I'm gonna see if I can pull it up.
Can you hear me better now?
I do. Okay, there's lawyer, I'm looking.
He posted like 17 hours ago.
Okay, here we go. I think you're right. I'm going to share this. I'm going to share this instead. Is this the comment?
Yeah,
What
that's the
to see if
comment.
this is legit before. Okay, right here. Sources are telling the U.S. Attorney's Office contacted the state and local law enforcement last week and told them the federal investigation of Karen Reed case has ended, per the Boston 25 News. But Lawyer No states right here, I want to see if this is legit before we dig into it too much. My dad and I have discussed it in the past. Let me put it in front of me so I can read it facing it if my computer will cooperate. And he always says they don't make those kinds of announcements as the norm, and that is true. But from time to time, it is highly sensitive matter or in an effort not to affect other cases. This type of things happen. I guess we will have to see if this is one of those cases. Tomorrow is going to be a big Karen Reed day, one way or the other, and that's
You,
how I feel.
you know, I have a huge problem. Why I don't think that they are I mean, let's say sure they stopped investigating Karen Reed case, but the what's the name, corruption can be, we are past International Space Station. We are like, aliens can see it from outer space, like the corrupt, how big it is, like, you know. Then it's what I talked to you yesterday, like it's how many Diddy and Farwell were arrested around the same time, right?
Say that again?
Diddy and Farwell were arrested around the same time, if I
Yeah.
remember right. How many times was Diddy in federal court? Many, right?
Right.
How many times was Farwell in federal court? Maybe once for like arraignment.
Well, but once again, then I was so grieved in my spirit yesterday because I am so look, if Karen Reed is guilty, she's guilty, she should go away. But I'm not looking at her innocence and guilt when I'm talking about how I felt yesterday. Yesterday, I was upset because it was a matter of um, the fact that Canton PD on multiple cases have been inappropriate, not handled things correctly. I'm not saying, let's put aside the banter that Canton PD officers unalived John O'Keefe. Let's put that aside, okay?
Mm.
There needs to be an investigation on the abilities of the department to manage and handle their department and their policy and procedures that are not being followed, which I'm sure are there. And they need some outside source to come in and do an audit of a lot of their cases and see if this lack of ability that they have shown to perform a proper investigation is a pattern of behavior or is it selective? That is one thing. I'm just God, I just love that background. I want it.
Here,
I want that. I want that. But anyway. Oh, by the way, before I
yeah.
go on, yes, I changed clothes. I'm like this because I may be interpreting. I have a deaf client that really wants to watch on her work breaks the Karen Reed stuff. She's just fascinated with it. And this is a work uniform, and I have like 20 of each, 20 tops, 20. I have about 5, 6 cardigans. So I did change clothes last night.
Mm.
But I just really think that they need to have a very detailed investigation from an outside source.
That's what I was actually thinking. Let's say they close the case. What I was thinking, let's say it is true. The Karen Reed, the probe into the Karen Read investigation is done. But according to Google and according to like 99.999% of the people, and this we all agree on, either whichever you side are free Karen Read or not, or Karen Read is guilty, is that even though the investigation is over, doesn't mean it can't be reopened, which brings me to think that they put a stop to it for now.
Time
you
out.
know?
Yeah.
Time out.
In sign language, they just pause. Well, look, if they're
And then
saying,
because, and for some reason, I don't know why, but where there's public corruption, there might be also a RICO potentially, or some kind of RICO case, you know?
well, this is what when they
Because
say,
we have that those officers that were arrested that like for those licenses.
Mhm.
Then we have Farwell, also Sandra Birchmore. We have Aidan Carney. We have Duck case, and of course we have Karen Read case. But we have also the trooper that was that died during training. So that's like 8 cases connected one way or the other with each other.
well, and here's the thing. They're saying if it is correct, and I don't understand. By the way, I gotta ask forgiveness. I don't know why the captioning is no longer working. I don't know how to fix it, but I'm working on it. My captioning was always on my lives, and now it's not on in my live anymore. And I can't fix it. I tried for an hour yesterday, and I don't know how to fix it. I've gone to every setting I could think of, but anyway. There may be what's called an overall federal investigation into Canton PD as a whole. Does not mean that they may not investigate individuals separate from that. But it also may be that they've investigated everything, and even if they believe the Canton PD members were involved with the unaliving of John O'Keefe, or that there was a conspiracy or whatever, they may not have enough evidence to bring it to trial. And that's one thing I really would love to get someone's opinion on this, but they can't give it publicly. So I will be talking to them privately. But does not mean that the state level cannot go in and start an investigation, but they may had to be stepped back and wait until the Fed investigation was over.
That's why I think that let's say they don't have enough to arrest McAlberts and everyone involved for covering up the murder and setting up Karen Read. Let's say that's true. They don't have enough. But then let's go outside of the scope. Let's put Karen Read in a box, and we go outside of the box and investigate those other 7 cases that are connected to CPD and MSP, And when we put all those together, maybe we get a case that we can put everyone involved in jail or prosecute them. Because if you remember the commercial driver license paperwork that Feds unsealed, they didn't put names, they put cooperating witnesses. Witness 1, witness 2. I think there were like 2 people that cooperated,
Mm-hmm.
And I have no idea what's going on. Yeah. So and Farwell, the word on the street is that he's talking. So who knows? I mean, they clearly covered up Sandra Birchmore's case. So let's say they didn't cover up Karen Read case, Let's say everything was by the book, which was not clearly, but let's say everything was by the book. In Karen Reed case, it wasn't in Sandra Birchmore's case.
Yeah, I'm concerned. I am highly concerned. And it is one of those things that my heart is like in my throat, nervous for them today. And I'm also nervous for the attorney because here we've got the proverbial fan. I'm trying to get the closed captioning fixed.
Then I should not tell you what I
I don't-
found out earlier, because you will not feel any better.
Okay, it says that the subtitles are processing, so there's nothing I can do. I apologize, everybody. I really do. It says the subtitles are processing, and I can't do anything about that. Thank you so much, Yana. Yana, I don't see you.
Have you read about the ARCA people?
No, I have not had,
Good. Well, let's talk about it on the break, because
117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the
oh
Commonwealth?
my
Good
gosh.
morning, Your Honor. Laura
this
McLaughlin from
horrible
Commonwealth. Good morning, Ms.
audio.
McLaughlin.
Adam Wiley for the Commonwealth. Good
Good
morning.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan from the Commonwealth.
Good morning,
Mr.
Ms.
Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Lessie.
Good morning, Your Honor. David Kennedy for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms.
I'm very
Reed.
nervous.
All right. So last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial, with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each
Wait, Auntie Bev is saying she wanted to be fair. Has hell frozen?
other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott is going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel
Okay.
to all of your concerns. I have a notebook
So is he now the attorney for the attorneys?
that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Alessi.
You're welcome.
Thank you.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
Okay. All right, Miss Angela, your turn.
Shall I make you more mad?
Go for it.
Well, Trolls has done an amazing job on X and other social media. McAlbert Trolls or anti-Karen Reed Trolls, choose your name. That ARCA has closed its Twitter account because of bullying. And basically, I mean, it's textbook witness intimidation on Daniel Wolf.
That's insane.
I can send you the link. It's insane, one way to put it. And will Commonwealth do anything about it?
No,
Exactly.
they will bring charges against TB. And I got to say this real quick to a lot of my viewers. I am very careful about using other content creators' names on my channel, because I want to make sure that whatever we say concerning that person is 100% accurate. But I will say this. They are prosecuting TB in a way that I believe is unfair and unjust about the bullying and harassment. But it's okay for these people to bully and harass a defense's witness.
I sent you the link on Discord.
I see that. You sent me let me see. I will bring it up. Just give me a minute. I'm going to share this tab. I hate all these damn commercials because it's so hard to read things. So it says Canton cover up part 481 online trolls and egged on by Hank Brennan harass and intimidate family of Dr. Wolfie, prevent him from testifying.
Read. There is more.
I'm trying. It's small for me and I'm dyslexic.
Sorry. I thought you were.
I'm trying to enlarge so I can read better. There we go. I hope. See
I
all the
thought you were
see all the side crap on here makes it harder. From testifying, force ARCA to remove Twitter account and online reviews. So, disgraced ARCA expert Daniel Wolfie's wife, Dana Wolf, has left the Free Karen Reed group she was in, deleted her comments, and locked down her profile. Thank goodness there are screenshots. Get Daniel Wolf back on the stand and get to the bottom of the scandal. Okay, lied in the court about the U.S. attorney. I'm not going to get into that misunderstanding, as he calls
But
it.
read the troll comments. They are like insane. They're calling for
Okay, here
other
we go.
people to harass Daniel Wolf's family.
Okay, here we go. I'll read this. Brennan realizes how problematic the testimony of the two ARCA experts is for him, since they both testify at the first trial of John O'Keefe. Injuries couldn't have been from a car, and the damage to Karen Reed's vehicle is consistent with a motor vehicle collision. He can't get into a crash reconstruction expert of his own to testify that John O'Keefe was hit by a car, and that is true. You know, unless he can find one to do that, that's going to be problematic for his case. And then, because there's no one with a brain who would ever say that, but instead of going to the ethical thing and dropping the charges, Brennan is doing the only thing he can do, trying to smear ARCA. He's going to attack every expert witness. Keep going.
Perjury for hire. Should Daniel Wolf be punished for lying on their oath, and so on and so on.
Well, I'm not going to read all of this right now, but I will sit back and read it. We are coming back into court. So I need to get back over there. But I think it's ridiculous. And I noticed when he started trying to attack Dr. Russell, I was afraid he was going to start attacking every one of their good witnesses. So that to me is beyond acceptable. Beyond wide. Oh,
See what it was that you.
let me go back to here. Okay, here we go.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order
Want
because
the notebook.
I believe the best explication of the facts
I want the notebook.
and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my
What a vocabulary.
genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it.
I will.
I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor. And because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them,
Sure.
but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your
I will
number,
tell you exact
8.
pages that I'm going to refer to. And Your Honor, get to this is tab 8,
right.
the notebook.
Mhm.
And specific pages that I'm going to reference start on page 53.
Okay,
And those are 9 pages that proceed all the way to really the substance ends on page 62.
okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to
You
suspend my
can,
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go right ahead, Mr. Lessie.
Thank you, Your Honor.
She's like, I
So
want to hear.
I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts. But I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as your honor will recall, the trial one started in April of 2024. So it was pretty close to when that trial started. And I know your honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and the substance is important, your honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact, but either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know, but I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as your honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made.
You ain't gonna like that.
This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the hope.
Was the federal protective order that was referenced by Ms. Giannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, no, I wanted to say, I'm going to answer it directly. What Mr. Yannetti articulated as the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand.
Oh,
But I'm going to give you information that's going to indirectly.
that is the big issue right there. That is going to either save them or hang them.
Answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email. And my understanding is Mr. Yannetti is not knowledgeable about these communications. So The email reads, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly in COVID at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA's willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only for the non-evidentiary transcripts I reviewed was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Right.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire. And that the ARCA witnesses were going to have to come up from Pennsylvania and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question.
That's exactly
Oh.
what I said.
Pardon me?
Let
That's exactly what I said.
Yes. And I want to key in on, you've
Auntie Bev, this is not a conversation. This is not your living room. This is court. Let him speak.
never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes 2 people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides had. And I know the immediate response might be there. It might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor. And this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify, yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's, Mr. Yannetti says that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3, and it's the June 18,
Okay.
2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell.
Oh,
That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf.
Yep.
What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages, not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on it. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions.
That was what was read into record on the last motion that got all this started.
Questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email. So this is attachment Wolf Qualls document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18th, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor.
Now she's getting bored and wants him to hurry up and get to his.
The next tab, and of course, it has the D&T of Dr. Wolf's experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this.
Are we kissing ass?
Can you repeat? I didn't hear it.
You want to go back on that?
Just 5 seconds.
And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this.
He is kissing A here.
Yep, but it's needed. I mean, Commonwealth is kissing behind, all the time.
We call it brown nosing. Yes, they are brown. There's a difference. Commonwealth is brown nosing. That means they're getting a little bit up there. They're keeping their nose in it to get long enough to get brown. He's just pecking it to get away. He's kind of covers, but well, but I'm tired of her little snide remarks. I just shut up and let him present.
I have notifications of Turtle Boy on my phone, and he's reporting that she has the same attitude as last week.
Of course she does. She has the same attitude every time with this case, but I watched a case with her earlier this either in the fall in the fall, and she was a totally different person for that trial.
Because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14. And we heard on the 18th a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring, Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right? That are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue, because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up. Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know, a great deal of my work is in the field of lighting and visibility. So there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No, that's correct. Mr. Yannetti? No, fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question, when did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer, correct. Question, and that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say, this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement, to the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct. Question. As a matter of fact, I've never asked you specific questions about your testing before today.
Specific question.
That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in.
Suggest.
And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country.
True.
He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation. And
True.
he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will
You
not.
can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And I
If
said
you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Oh,
Your Honor,
Shut up,
first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I
Okay.
think the only way to fairly.
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
Here, I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No.
but it's
That's
reasonable
the
to
sense,
believe.
though, that was extant at that particular time.
Okay?
So we then go down to the next question.
It's reasonable to believe.
But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out, correct? Yes. And I called you ultimately after receiving your report and asked if you join us and testify, correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf. And I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle? So it's important to know in terms of, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, you know, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. These are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, not understand, the date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation. Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome. So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, about the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's important, very important question. But it's an important fact point as well that that call was made. So in terms of the next tab, which I've been alluding to during
Okay,
my,
so this is the one I said I needed to take a
I
recess
was
to
just
read
going to
that.
say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
All rise.
You are muted.
And I'm unmuted. I can't share the link because it's Google Maps. But if you go to Google Maps and 34 Fairview, and then go to like Street View, so you can walk by.
Right.
34 Fairview is blurred.
I'm going. Hold on.
You can see the house only from one angle.
Boy, I tell you, that thing's been researched a lot. That popped up real quick. It's blurred. Oh,
Yeah, you can only see it from one angle. Not only that, look at the house across the street where allegedly there was a ring camera that the video never came out. It's across the street.
You guys, I don't. Oh, there. Okay, so John O'Keefe. See where my arrow is? That's where John O'Keefe's body was. Right here. Right there. Okay. And
That wasn't ages ago. That was recently. I was on 34 Fairview like weeks ago.
I was too. So it's blurred.
And the
And-
house across the street that belonged.
House. Both of those are police officers.
I can hear you.
Both of those are police officers. Well, this has been sold. 34 Fairview has been sold.
Okay, I understand why for 34 Fairview is being blurred because for the privacy, but I mean, from my understanding, the house across the street is still in the hands of, or the family of whoever lives there. But they are like police family or whatever.
Hmm.
But that other link that I sent you from Arca, I mean, on one hand, I do understand because it is high profile and a lot of people, it's privacy issues. That they made a great. They even made towards the end like not calculations, but they measured. Like if you take that and put onto the street of 34 Fairview, it's
I can't get my upper half is hot. My feet and legs are cold. There's no sound.
no. Case one, I don't think it's a cover up. I don't know why they did it. It may also have to do the family has sent in a request for privacy reasons.
Run the other way, she wouldn't have been hit.
Yeah, but but look at now calculations, or I think you need to like go a little bit for.
No, it's measuring right now.
Yeah, it's measuring. They don't say how fast the car was traveling, but that's about the same. I don't know from the top of my head, but I think it's about the same distance.
With Karen Reed.
Yeah. And look at that. She went forward. She did not go up and, did a ballerina dance. Did not become all of a sudden a professional ballerina,
Spin.
Yeah.
No, he would have gone. Yeah, I'm with you. They went to every camera in that town.
I agree. I agree.
I think he is doing a very good job.
It may have been the
Yes.
house today.
That house across the street was the house that they went and got the red Solo cup from.
Speaking of red Solo cups, so I have, I think my friends are starting to be bored with me because all I talk about lately is this case. And like, I can't wait for a retrial and for a jury to
Will you
find.
be joining us for that retrial?
What?
Will you be joining me for that retrial? Or at least watching it?
Watching, yes. If I have time to join you and talk about it during, I will try. But my plan is also to get some work, which as in start. I want to move. So, and in order to do that, I need to get steady job. So we'll see.
Well, you're welcome. I don't like to do really much commenting during the trial.
I understand.
If you want to hop in, you're more than welcome to.
Oh my gosh! Thank you for reminding me.
Boston,
Do you know?
I think the owner of that house is the police chief of Boston PD.
Yeah. Speaking of chief, do you know who is in the courtroom?
Who?
Chief Rafferty.
I didn't see.
Well, according to X, she's in the courtroom. or at least courthouse. I don't know if she's in the courtroom, but she is in the courthouse, and she got to the courthouse with O'Keefe's.
Oh, interesting. Very interesting. Come on, where's my mouse? Come on, follow me. Wake up. My mouse has these buttons where you can change the slow to super fast movement. And sometimes it just switches on its own. It's like, dang it, stop it. I'm going to hop on over to
I was
No.
looking. While you look at that, can I say something? I was looking at the timeline, and as I suspected, there is like a very clear timeline. And according to Google, if I understood the right termination, right words that Alessi said, like, oh, we need to follow these rules and what the name of the rules are. According to Google, the defense more than followed the rules, you know? They were like, they didn't even want to imply that they didn't follow the rules, you know? Like, I didn't contact Dr. Wolf. Dr. Wolf contacted me, and here is what he said to me. But that was also said during the trial, so we are squared away, you know?
Well, one of the things I wanted to say is right now, I don't hear that they had retained the person as a witness. There was no agreement. There's no agreement for payment. There was no agreed. And I agree with what he's saying, because when I was trying to help my husband with his case and I was going to testify, I remember sending an email to the lawyers requesting certain information, like what is going to be the questions, because I was nervous as hell.
Yeah.
And they said, under certain rules, we can't do this. And so I didn't email anymore, but I understand why the ARCA person may have done it, but he doesn't know the rules. And it's not for him to know the rules. But if the trial was already in progress, there does not seem to be any emails going back saying, I'm going to ask you this. None of that happened. You cannot hold a lawyer accountable for what a legal person, a layman, is what we call a layman, who is going to testify for what they email them and what they ask. You can't control that. I
But-
could sit there and ask for the stars and the moon and every volcano on Earth in a diamond ring, and they're going to say, we can't talk about this. Doesn't mean he broke Rule 14.
True. And on the other hand, does not mean that so the trolls does not get the wrong idea. It does not also mean that Dr. Wolf is unprofessional, as in him contacting Jackson and, you know, asking what he asked. This case is unique on so many levels.
It is.
Dr. Wolf has testified God knows how many times, and he had some kind of talks with the defense, which did not include per se witness preparation and so on, but there was talking, there was communication back and forth. Here,
Had
because of the FBI,
have a federal order.
yeah, because of that order, they could not have talked. So I completely understand, and I would have reacted the same way as Dr. Wolf. Like, I mean, it's weird to not talk, to testify for any side. Doesn't matter if defense or Commonwealth. it's weird to not talk about them. Like even simple, like, oh, I don't know if they are able to say this, but I'm gonna like I would love, maybe not this way, but like I would love to, I don't know, point more to, not exaggerate, but like give more weight to certain points, like to I don't know, let's say that the point here is that the car did not, based on the evidence we have, the car did not hit John, and John was not hit by a car. To exaggerate that on the way that so jury can understand it, maybe something like that. But they were not even
Right.
able to say that,
Well, here's the thing. It's one thing for them to say, now I did ask this question. I'd taken notes of my memory. And I asked, can I have it with me to refresh my memory? And they said, no, not for this. You cannot. But he, as an expert, can, and he could have brought a copy of his report. So if in that email he's saying, look, I normally get asked, do you have copies of your report? There's a lot of prep in, you need to be here at this time. This is our plan. This is your travel, yada, yada, yada. And there is usually a lot of communication between the witnesses and the law firm. Shoot, I got to answer this. It's a doctor's office. Go ahead and keep sharing.
But what's interesting to me is that I love how Alessi, and I hope that Alessi or whoever does the cross in the trial to point that I think they did it also in the last trial, that ARCA was available to both defense and the Commonwealth. While the defense did call them and jumped to call them, the Commonwealth did not. And wasn't they like saying like 90% or whatever percentage of the TUI release was like, oh, it's proving that Karen Read is guilty, and somewhere in those 3,000 something pages is ARCA report, which is saying John was not hit by a car, the car did not hit John, so I don't know. This I don't know. It's
Well,
crazy.
I'm with you on that, and I understand. The one thing that I'm just kind of feeling bad is that I really think that what has happened here is now all this attention and wasted time and energy on today has taken time away from Karen Read's trial. And I think that the prosecution wins a little point in that, because every minute they're defending this is like 10 minutes away from working on her trial. And I really hate it for her.
I hate it. So I hope that I hope they make a motion to push the trial, because if we are going to have the Dow,
Judge is not going to do it.
I know, but because if we are going to do the Daubert or whatever, Daubert hearing on the two Commonwealth witnesses, that's going to need to happen in like next 2-ish weeks.
Yeah. And the thing is Auntie Bev is no longer in that part of the court anymore. She's in family law. She is holding herself to this trial, but she is no longer in criminal. She's in family. So now she's balancing this trial along with family court. And that to me is,
I feel sorry for the families.
I feel sorry for the O'Keefes, because John is not getting justice, neither are they. but they think Karen Reed is the justice, but she's not. I don't know. Don't forget the Commonwealth thinks it's Palbert. Yeah. Did you see all the misspellings and everything? I didn't go back and count it. I wish somebody would. How many typos and anything that followed the word of the was all one word.
Shall we not forget the hashtag value instead of hash value? Hash value, yeah.
Yeah, I thought that was funny.
That was funny. And I was writing a paper on what's the word? On cheating at university. And one of the papers that I found, and research papers that I found, was like how we can use forensics to see the forensics tools to detect whether or not someone cheated, based, like if I was to contract, for example, you to write a paper for me instead of me writing for myself, to look into metadata and so on. And one of the things that they are like, oh, you can do all of these things, you can, and one of the things was hash value, and they gave example of hash value. I was like, that was like a few days after like that whole hashtag debacle.
Look, they're human. They're going to make mistakes. They're nervous. These people, I don't care what side you are, the stakes are so high. There's sweaty palms in that room. But it is very difficult, and I wouldn't want to be in that room as a lawyer on either side. But hey,
Sorry.
This DA, special DA, is playing dirty pool big time. He's trying to squash all the witnesses he can to weaken their case. None of us is perfect, but if you get to proofread those legal documents damn well better be as perfect as you could get them. I can't believe Angie Judge accepted that legal document.
I can't believe she accepted the motions without affidavits by the Commonwealth.
Yep.
Isn't that like a must do, like add the motion, add the affidavit?
I'm not sure. I would think that if there was an affidavit available, and then it should be attached, in my humble opinion, but I'm not a lawyer yet.
Did I tell you that I sent Mr. Yannetti? I got a hold of Yannetti's law firm, and I got a hold of how to send. It's an assistant. She's lovely and really nice. I sent that paper on blood alcohol content. So I hope that they find someone that can testify to that and explain what the bloody heck went wrong in calculating back.
Well, but also I said in an interview that I thought was going to be out today, that I did for another channel, that with her medical condition, her body may process that alcohol differently than what is considered to be the norm. They got to take all that into effect. And of course they don't.
Commonwealth won't, but hopefully the defense will.
One thing we did learn from the last trial, and we did learn from that juror who spoke to TB, was they were more worried about the fact that she was drinking and driving that night and that she needed to be held accountable for drinking and driving. Although the charges were not quite that. And I felt the jury was focused on the wrong thing. Because if they're going to try and hold her accountable for drinking and driving that night, then why isn't all the police officers who were drinking and driving that night? What about the alcohol content of everybody that night?
Yeah. What about speaking of everybody of that night, do you know whose cross I'm looking forward to? Jen McCabe, of course, who doesn't? I'm gonna have like two ultra mega bowls of popcorn during her cross. But one more that I'm looking for is Higgins. That's gonna be spicy.
He's kind of been the sleeper witness, but he did admit to them having a kissy.
Yeah.
I don't know. It's just going to be different.
But why I'm saying back to the jury, that's why I said I was also thinking of the same thing, what juror said and what he said the jury was thinking, like laying a lot of weight on her drinking and driving and so on. That's why I hope the defense calls someone to explain the whole BAC and what can impact BAC, and also poke a hole, because after I found that paper, I was scouring the internet, like what other things can impact BAC and what can go wrong when calculating back BAC like they did in this case. One thing all websites had in common: you have to put in what that person ate and when they ate it, because certain foods can help absorb alcohol and actually lower as sugar can go up within the as sugar can make sugar and carbonated water, like in this case, can make the blood alcohol content higher. Certain foods can make it go lower, So did they do this in this case? Did they ask Karen what she ate, when she ate, and what she drank, which is very important? No, they just did what they did.
Well, and the other thing is just because you paid for something and you ordered something didn't mean somebody else didn't drink it.
I followed this girl on YouTube, but she has a TikTok as well. She's a bartender, and she makes skits and all of these funny stories she stumbles onto as a bartender. And do you know how many skits she has where like people, can you make this made up drink that someone saw somewhere or someone made it at home, and then what they put on the table, because that made up drink is not on the cash register, so they have to put something that is equivalent to that.
What's called it's a custom, and they have to bring in 1 ounce of whiskey, 1 ounce of whiskey sour, 1 ounce of cranberry. So they individually ring up the ingredients for that drink.
Yeah.
It's called an itemized ring up. All right, Auntie Bev, let's hear it.
Yeah.
May I continue, Your Honor?
Please.
Thank you.
Don't ask, just keep going.
So, Your Honor, to blend and quickly summarize what we've gone through, I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We talked about June 10th and statements of counsel. We've talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson in the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53.
Okay.
Okay, people kind of got off on him because he's doing that. He's kind of saying, I'm going to do this, and then he does it. And she's getting a little pissy about it. Remember, this is not his standard. This is not his jurisdiction. This is not where he normally practices. So he doesn't fully understand how she runs her courtroom. So he's really behind the ball and learning as he goes. She is very impatient. She's forgetting that fact. He is trying not to do anything to add fuel to this fire. And that is so true because she's a volcano ready to erupt and any opportunity. So he is trying to give her a roadmap to where he's going. So if he's going or operating in a way that she does not like or prefer, it gives her an opportunity to do what she just did. And I respect that.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them and I'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important because my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be, in some points, a line by line because the words matter. Line 5, and this is again is Attorney Brennan.
Mm-hmm.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now, I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance.
Multiple.
And believe me, I can empathize with Attorney Brennan.
He has said many times, I wasn't here before, but I read the transcripts. Dude, you sometimes miss a lot between the lines in a transcript.
And on that, it's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his comment here is I've read the transcripts and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup. which is at the bottom of page 55, Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about
Limited.
interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told a complete story. So there was, and I'll tell you, my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds? When he really got it from the defense. There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next on page 57, line 11, he reads,
I guarantee they would
response,
not pay
Hi,
it.
Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Ellen. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information?
Are you there, babe? Can you
Yeah,
hear me?
I'm here. Yeah, I can hear you.
I don't know why the internet went down.
I thought it was me for a second, but
No, I'm going to have to close out all these windows. I don't know. I'll have to pull it up later. But
Information as I can. It's incorrect statement number 2, and it's an
sorry,
important
guys.
one.
I don't know what's going on.
Down below,
I have the best
unfortunately,
internet.
it gets even more incorrect. Defendant
Problem.
provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. My, that's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll start back up at 2.
Okay, Your Honor.
Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a
That's
time
my
frame.
best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
Oh, okay.
You are muted.
well, unfortunately I can't
There's maintenance apparently going on with something that knocked us off. Okay, go ahead, my dear.
Unfortunately, I will not be able to join you in the afternoon because I have some other plans, and I also have an exam on Friday, so I need to study for that. So
Well, look, I have 2 weeks away will be my final exam. Oh,
I may have suggested to my teacher that we need to do a case study of this in criminology to look at it from criminological point of view.
so
Yeah.
what are you studying?
What do you mean? What am I studying? I'm studying criminology, but
What do you hope to do with that degree?
believe I was first thinking of working in customs, border and customs agency. But then I learned I can work for the Swedish version of IRS. And I was like, yes, thank you. I love numbers and I love to trace things. That's why I was thinking of border patrol or border customs and border. Something along of that line. Because chasing criminals is fun.
Well, I got to figure out what I'm going to do with my criminal degree, but I do want to go on to the master's and then the doctoral.
Well, that's my plan as well, but I still hope that I may work something practical, as in either Swedish version of IRS or even Border Patrol. Well, not Border Patrol, because I don't think I will. But, you know, the detective part of Border Patrol, you know.
But don't you have to do the other part first?
No. Yes and no. Depends on how you enter, how you apply.
And it depends on your degree in education.
Yeah.
Cool. Well, I wish you all the luck.
But wanna check out that link that I sent you regarding our favorite DA?
I will. We will go through it in just a minute. I had to close all this down thinking it was me, and it wasn't me. It's the internet providers or power, whatever, because it happened exactly at noon. And so I was like, dang it. No, not today of all days. No.
No. But while you put this out, I mean, it has been pointed out by many people that, like, how is Lali still a lawyer? How is now even Brennan? Maybe Brennan has not crossed that stage yet that he needs to be disbarred, but I mean, there has been pointed out regarding Brennan that he may have trouble retaining clients after he is done prosecuting Karen Reed. Doesn't matter what the outcome is, because who will trust him to defend him, you know?
Well, this was my plan. We were going to go over to the Simatilli trial during this break. I want to wait till the end of the day, and I'll go through some of the stuff that you have, and because I don't want to get in the middle of that and then have to stop.
Sorry.
At the end, oh no, at the end of this hearing today, we are going to go through some of the stuff that you sent. So if you are free to hop on, then great. If not, no problem. Thank you so much for joining. I appreciate
Thank you.
it as always, and I love that background. Did it come and you have to put it together?
No, I'm at the university, so it's one of the rooms.
Oh, it's one of those study rooms.
Yeah.
Oh,
Yeah.
that's cool.
And unfortunately, it's dark outside, and I can't show you the outside because you just see like darkness and maybe light here and there. But next time I'm here and it's light, I'm gonna show you the beautiful view from the library. It's like there is no more beautiful view from a university library than this.
Take a picture and put it in Discord.
I already did. I'm gonna repost it again. But it was cold, so the channel, it was like icy, so you didn't see very much. But when it's nice weather. So yeah.
Wow. Well, you're so blessed to be there. What time is it for you?
7:10 p.m.
7?
Yeah, 7 p.m.
7 p.m. Well, you have a good night if I don't see you.
Yes, you too.
Thank
Bye.
you so much. Bye-bye. Okay, guys. So what we're going to do, we're going to swing on over here just for a little bit, just to get our What is going up with that? No matter where, there it is. Uh, just keep our nose into this trial. We need to. All right, let's go. But we will, yeah. It's an hour ahead of you. So Haley Mounts, it's 6 p.m. your time. That's awesome.
Face me and raise your right hand, please. Do you solemnly state this testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please have a seat in the witness stand.
We're going to speed this up a little
And
bit.
for the record, say and spell your first and last name, please.
Alicia Truesdale, AMI,
With Wella.
21 this June.
Okay. And
Okay.
for the record, say and spell your first and last name, please.
Alicia Truesdale, AMI, CIA, TRUESDALE.
Thank you, Your Honor.
Good morning, ma'am. Can you tell us how it is that you're employed?
I'm currently employed at Wella Company.
And what do you do at Wella?
I'm an administrative assistant.
And how many years have you been with Wella?
21 this June.
Okay. And who are you an administrative assistant to?
Currently,
Yes.
Martin Dale, and also I assist Mika Quinn.
Okay. And previously Carol Protat?
Yes,
And did you know somebody by the name of Fabio Cementili?
yes, I did.
And did you work with him
Yes, I did.
for approximately how many years?
Probably 5 or 6, 7 years.
You were his executive assistant,
Yes,
showing you people 73. Do you recognize who you see here in this photo?
yes, I do.
And do you know all these individuals?
Yes, I do.
And is this Fabio and his children?
Yes, Luigi, Jess, and Bella.
And when did you first meet? Do you know approximately?
It was quite a while ago because when he came to work for us in the United States and did a stage show, we were, it was quite a while ago. And then he went back to Toronto and he ended up working for Wella in Canada. And then eventually he came down to the United States.
And once he came to the United States, did you see him just about every day when he was in the office?
Yes, mhm.
And did you also know his entire family?
Pretty much most of the family, yes.
Okay. Did you know his wife?
Yes,
Do you see her in court today?
yes, I do.
Can you identify her, please?
It's Monica Cementilli. She's sitting right there.
Indicating the defendant.
Thank you. And you also knew Fabio's sister,
Yes,
Morella,
yes,
as a platform artist for Wella as well?
yes.
All right. And had you been to the Cementili home in Woodland Hills many times prior to Fabio's death
Yes, several times.
for work meetings, parties, things of that nature?
Yes,
And were you responsible for keeping Fabio's schedule and with all of his daily meetings and his travel?
yes,
And did you always, as a matter of course, send him his agendas every time he traveled?
always.
Okay. Did you also send them to the defendant so that she would have a breakdown of where he was when he was traveling, along with contact information and things of that nature?
Yes, I always did as an emergency measure, usually.
And did you also handle any financials or work expenses for Fabio,
Yes, all of them.
including his travel mileage and things of that nature?
Yes,
And also worked with him or put through his paperwork for his life insurance and all of those type of things?
he actually handled that too with the company, but I was aware of it.
And did he and you have a very close relationship?
Oh, most definitely.
Okay. And did you also go with him to lead team meetings and trendsetters and various functions and events?
I did accompany him on several events, actually.
And where was his office located in relation to yours?
Right across from my cubby.
So he was, you were just outside of his office?
Yes, mhm.
And when he was at the office and not traveling and actually working just outside where you would work or inside where you from where you worked, did you often speak to him throughout the day?
Oh, all the time.
Okay. And did you also note whether or not when he was in the office, if he would commonly speak to his wife several times throughout the day?
Yeah, I know when he'd call her, she'd call him.
Did you ever hear him refer to the defendant by a nickname?
Yes,
Pootsie?
Pootsie.
Did you know him to be somebody who would often leave to go on date nights and things like that with his wife?
I know he would mention it. that he had a date with his wife.
Did it seem to you that he loved his wife and family?
Adored her and them.
And on a typical work week, if Fabio wasn't traveling, was it also common that on a Monday or a Friday he might work from home?
He might, yeah.
And when he would work from home, or if you would go to see him and he was working from home, or if he had meetings from home, where would those take place?
Sustained.
When you went over to the house for meetings and functions, where would those meetings take place?
Out on his patio.
And when you spoke to him while he was at home, would he check in with you regularly throughout the day on days he worked from home?
Yeah, he'd want to know what was on his schedule, or I'd have to get a hold of him if somebody needed him.
And was it also part of the business plan that he would often post on social media to the beauty industry from the patio?
From the patio, from an airplane, all over.
Okay. There was something I think that he would do called Fab Style Fridays.
Yes. Mhm.
So this was part of his work where he would post things about trends in the company, upcoming events, things of that nature, tips.
It's the only way any company is running now.
And over the last year before his murder, did it seem that he was traveling internationally or traveling somewhat less?
Somewhat less. I had suggested that he not travel quite so much.
And did you attend a lead team meeting that took place down in, I think it was Torrey Pines, San Diego area in June of 2016?
Yes.
And did the defendant come to that event
Yes.
along with Fabio's team, the lead team?
Yes.
And was there a dinner during the nights that you guys were down there in San Diego?
Yes.
And did Fabio come with the defendant?
Yes.
And did it seem like their normal relationship to you back in June of 2016?
At the dinner.
Go ahead.
At the dinner, it was, conversation as usual, kind of thing. We went to an Italian dinner place, but it seemed as the evening kind of went on, it got a little, I don't know. It was a little different.
Different in what way?
Well, it wasn't quite the camaraderie, I think, that we normally experienced when we were all together.
Okay. And what did that have to do with the relationship between Fabio and his wife?
I'm sorry.
Was it their relationship that was different, or was it his relationship with the lead team?
It kind of seemed his relationship with all of us.
Okay.
Kind of seemed.
He seemed quieter.
Mhm.
Is that yes?
Yes.
And then during the dinner, did you all make plans to go out for drinks afterwards?
Yes, we did.
And did Fabio and the defendant go with you guys? to
No,
the-
they did not.
Was that unusual as well?
Yeah, usually Fab would stick around for a cocktail.
And the next day, did he have you cancel his golf and the defendant's massage?
Yes.
And was there anything about the defendant's behavior during that event in June in San Diego that was unusual that you thought was odd?
I thought it was odd that he had me cancel those things because he specifically had me plan them. And he loves to play golf. And then at the breakfast that morning, I felt uncomfortable. I thought it was kind of strange.
What?
That Fab seemed to be hanging on her, or kind of being over affectionate, I guess, with her.
Okay. And that was unusual?
I thought it was. I thought that normally he would be part of the group.
And what was the defendant's demeanor?
Quiet.
Was she also affectionate with him?
No.
More standoffish?
Yes.
Did it seem like he was trying to please her?
Yes. That's what it appeared to me.
Now, on the date of Monday, January 23rd of 2017, do you remember that day?
Yes.
And during that day, did you know that Fabio was going to be working at home?
Yes.
Thank
And
you, Toxic.
did you have a conversation with him somewhere around maybe 1:30, 1:50 in the afternoon?
Yes.
And to check in with you?
Yes.
And at some point later, did you learn that Fabio had been murdered in the backyard of his home?
After I came back from class, yes.
And after the murder, did you go to the Cementili residence?
I did not. I was
I'm talking about the days after.
days after, yes.
And during the days after, did you come to the residence several times in order to bring food and things of that nature and provide support along
Yes.
with other individuals from Wellness?
Yes.
Now, in the days following the murder, was there a particular subject that the defendant wanted your assistance with?
Totally.
Yes,
What was that?
life insurance.
And what did she say to you, if anything, with respect to the life insurance?
She wanted to know if, well, she had said to me, she says, Henry hasn't gotten back to me. Henry being the lead, the head of HR,
Henry Meyer?
Henry Meyer. And she seemed agitated. And I said, it didn't seem like them. They were usually very good about getting back. And I did say to her that I would go back and mention something to Henry, that she had brought it up to me.
This is when you were at the house?
Yes.
And
So let's pay attention to this, because what I'm finding interesting is she didn't call just one person about this insurance situation. She was calling 4 and 5 people in one time, in one day. If, say, John didn't give her the information she wanted, she called Ron. If Ron didn't, she called Erica. If Erica did, and these are made up names. So she would literally just go from phone call to phone call to phone call about this money. Now, if she promised to pay people to unalive her husband, they're going to want their money pretty dang quick. They're not going to sit there and wait a year or two before they get their money. So this to me is, if I'm a juror, I'm thinking that's a lot of people that have testified in the same frame that she's calling them over and over again. Just my observation.
what was she doing when you came to the house?
She had paint samples. She was getting some remodeling done in her first floor.
Why would you?
Did she tell you that the insurance company had given her money
Yes.
to do that?
Yes, she did.
All right. And what, if anything, did she say with respect to the life insurance?
Just that she wanted to know what was going on with it. She wanted to know where she wasn't getting any kind of response, she felt.
And did you have another conversation
She
with her
didn't like
subsequent
the
to that one
response.
again at the house where, again, she brought up that same issue?
Yes.
And did she question you about what the delay was with respect to being paid Fabio's life insurance?
She said she didn't understand what was taking so long.
Did she seem upset when she was talking about that?
She seemed agitated.
Did you describe previously in an interview that she was very upset?
Possibly. I mean, I just know that she was upset. She was anxious to get the money or to get it settled.
Did you know during that same period that she was receiving Fob's full salary?
Yes, I did.
Did she contact you with another issue that she wanted your assistance with?
Yes.
What was that?
She said that that her girlfriends were telling her that she should get out of town.
Okay.
And she had asked, I think you mean something else.
No,
that I
go
said.
ahead. I'm
Okay.
finished your answer.
So
Go ahead.
she did come and ask me, or she called me and asked if I knew of any deal she could get in Las Vegas. And I said, I would not be the person to ask that. Really, Melanie Garibay was the one that had the connection in Las Vegas.
Okay. And prior to this Las Vegas event, is that where she said she wanted to go?
Prior to the Las Vegas event,
No. Did she say that she wanted to go to Las Vegas? Is that what she said she was going to do?
she
with
said
her
she was
girlfriends?
interested in going to Las Vegas to get away. Yes.
With her girlfriends.
With her girlfriends.
All right. Did she also ask for your assistance in
You're
obtaining
right.
Fabio's travel mileage?
Yes.
I assume since Fabio traveled often that the
Yeah.
company, through the
Yeah.
company, he would have acquired airline mileage?
Yes.
And that there was a significant amount?
Yes.
And what did the defendant ask you to do?
She wanted them transferred over
To
herself.
Okay. And did she ask for your assistance in doing that?
Yes.
And did you go to the house in order to get a copy from her of his death certificate in order to process that request?
Yes.
And did eventually you accomplish that task for her?
Yes.
After the murder, did she also ask for your help in setting up a wake or a memorial at the home the following week?
Yes.
And did she tell you what she wanted?
Yes.
What was that?
It was a particular Mexican restaurant or Mexican caterer that we had used before with Fabio.
The taco lady?
The Nana's Tacos, it's called.
Okay. And you assisted her in setting that up, or you took over that project?
Yes, I took it over.
All right. And did you attend that event?
Yes.
And who who were the attendees or the people that were invited to attend this event at the Cemetery home?
At her request, she had asked that it be employees that would work with Fabio and very close friends.
And family?
Yes, and family, of
And did
course.
you reach out to the family, Fabio's family in Canada, in order to assist them with their arrangements?
Oh, yes.
Hotels, flights,
Yes.
things of that nature?
Mhm.
You ensured the payment for all of that?
Yes.
All right.
Mhm.
And on that following Sunday, January 29th of 2017, did you notice when you were at the event in the backyard that you had assisted in setting up or had set up, anything unusual with respect to her behavior there?
Overruled.
I thought that it was a rather dramatic behavior that was going on.
And did you notice whether or not she was sitting with somebody or with somebody that you didn't recognize?
Yes.
And did you speak to that individual?
I believe I asked, I didn't know who he was. I said, who are you?
And did the individual tell you who he was?
He simply said that he was her racket. He played racquetball with her. He was from the gym.
Other than that one individual.
Sorry, I didn't know
where-
someone or
do you
something was.
recall where they were sitting?
Almost across from Fabio's chair that was kept vacant because
I want to show you exhibit 921. Was there a particular chair that Fabio sat in whenever you met with him out here on the patio?
yes, the one over in the corner.
This one here?
Yes.
Okay. And where was this other male seated? The one that you didn't recognize?
On the sofa.
Across from
There
her?
might have been a chair there. I can't quite remember. There might have been a chair next to the sofa, but it was over in that area.
Other than that individual, did you recognize everybody else that was there in terms of their being close friends,
Yes, there were a
Fellow
few
people?
neighbors that had shown up, but they introduced themselves to me.
neighbors? Nobody else that was
No.
odd or unusual?
No.
Now, when you mentioned that her behavior seemed dramatic, can you describe for us what exactly you witnessed?
I felt there was like a lot of loud sobbing and just very dramatic, very over the top kind of behavior.
Did you see any tears, like she was actually crying?
Not really.
Now, did you also assist in setting up the memorial that Wella put on for Fabio in May of 2017?
Yes, I did the whole thing.
Okay. And when you were arranging that particular event, did you have multiple conversations with the defendant about what was going to occur at the event?
We had a few conversations.
Okay. And did you see when she came to the event at the Wella offices that day?
Yes.
And were you surprised by anything at that point in time?
Yes.
Overruled.
What was it that you were surprised by?
She drove up in a brand new, full everything package Mustang. And I was rather surprised because she had said, I had heard that she didn't want to get rid of Fabio's truck because it reminded her so much of him. So I was a little surprised.
And did she tell you that she wasn't going to get rid of his truck because it smelled like Fabio?
She had mentioned that.
And did you direct or did she go somewhere as the when she arrived before the event started?
Yes, I had them sit right in Fabio's office.
Okay. And what was she doing? Did she send you to get her something?
She had asked if we had wine.
So she was sitting in his office drinking wine?
Mhm.
Is that yes?
Yes.
At some point in time, you told us about when she asked you for a connection for Las Vegas. At some point in time, did she mention to you that she was also going to be traveling to Myrtle Beach?
She had mentioned something.
And did she tell you that she was going there because that was a place Fabio had always wanted to go?
She said something like that. Yes.
And had Fabio ever mentioned going
I
to
had
Myrtle
never
Beach?
heard it before.
Did she tell you she was going with her lover?
No.
Did you know during the year preceding Fabio's murder in 2016 that she was having an affair?
Absolutely not.
Was that something that, if it was happening, perhaps Fabio would have mentioned to you, given your relationship?
Stay.
Did he ever mention that he suspected
Never.
his wife was having an affair?
Never.
When you sent travel agendas to the defendant, did you also send them to an individual by the name of Robert Baker?
No.
I have nothing.
Good morning, Ms. Truesdale.
Hi.
You previously testified that back in 2017 and during the years prior, while you were working with Fabio, that he might work from home on a Monday or a Friday, depending on his prior travel schedule. Is that right?
Yes.
But there was no set day that it was always the case that a Monday following some sort of travel that he was absolutely for sure going to be working from home as opposed to in the
It
office.
depended on what was going on in the office. If he had meetings that he had to be there for, he was there.
And on January 23rd, 2017, am I correct that Fabio called you that morning to inform you that he was going to be working from home that day?
If I'm not mistaken, he had suggested it the week before that he might not be in on Monday. So, but he did let me know, yes, that he was not going to be in the office.
He affirmatively called you the morning of January 23rd.
He might have sent me a text.
Okay, but it was that morning that he had informed you and asked that you
That he was
cancel
going to
his,
stay home.
his appointments for the day. And you were also aware that Fabio had a colonoscopy appointment that day
I was told, yes, that he had a colonoscopy appointment.
by Fabio?
I think, yeah, I believe it was Fabio that had mentioned it.
Okay. And you later learned that Fabio didn't have any colonoscopy appointment that day?
That was objection, that was speculation.
But it was normal that sometimes Fabio would play hooky from work on a Monday or a Friday, right?
I wouldn't say hooky.
You testified that prior to Fabio's death, you had suggested to Fabio that he travel less for work. You remember that?
I've been thinking. This is what's hard for me. I'm not an attorney, but I have been thinking and mulling over this stuff about the ARCA bill. Would be prior to testimony. So I've been asking a lot of questions. Why was a bill sent to them in July? They did go and they did inquire they should pay or they paid the bill. So it, I don't think so. Is it discoverable for the new trial? Yes, it is. Is it discoverable for the old? No, it is not. So when they sent that information to the defense, they did what they were supposed to do, in my opinion. In my humble opinion. Uh,
Dr. Wolf
Let me
to
go back
Mr. Jackson in the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf, July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53,
Okay.
line
you love
19.
his thoroughness. Sometimes it can be
And this is
monotonous.
Attorney
I
Brennan.
love it.
Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive
Okay, Haley Mouse, let me do a recap. I don't know why the mic is in and out. I haven't changed. I just replugged it in. I don't know what's going on. I'll have to buy a new cord. I don't think it's that, but we'll see. And I will tell you, sometimes it's other people because one person will say it's in and out. One person says it isn't. If you see someone say your mic is in and out and you too are hearing that, please say same here so I know. Okay. So what he's saying, him, pointing in the right direction, him. I got to point in the opposite direction. What he's saying is, Your Honor, there was a federal order that we had to follow, and which is unusual to have a federal investigation with a grand jury investigation. I mean, that this is totally unusual. And then you have the ARCA witness is emailing him because he's not getting the communication he's used to getting when he testifies. Because of the federal rule that they had, there was a lot that couldn't be discussed. So the point that I'm trying to make is, in a very roundabout way, is number one, ARCA witness reached out to the defense. The defense did not send him a group of questions and say, this is what I'm going to do. This is what I'm going to ask you. That was never there. Number two, there was not a payment agreement at all prior to the testimony. There was never a one-on-one meeting with the defense attorneys and the witness for ARCA. There was only text or emails sent back and forth, and very minimal. So when under oath those questions were asked, they were true. Now, it was a surprise when the defense in July gets a bill months later for this testimony. They called, I guess it's a U.S. Who was it that they called? The U.S. attorneys. Let me see who that was. Let me see what it was. So pull it up. I'm trying to remember the name of the exact name. I'm looking it up. But anyway, they must have called the proper authorities to say, "Hey, are we paid this? How much is it paid?" So they said yes. So they did. So I assume there's going to be a phone call to the agency to verify that that happened. Cutting in and out again. Why? Nothing. June, why am I cutting in and out? That's 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 I'm trying to look at my monitor. That's I gained it down a little bit. Let's see if that helps. And I'm right on it. And I hate being right on it. I prefer to be back. Okay. So the federal investigation, let me get geared back because that cutting out kind of threw me. So I guess kind of like the attorney general's office, they contacted the right authorities. They said, yes, you can pay it. So it was not a lie at the time that the testimony had happened. There was no agreement to be paid. There was no discussion of that. So I'm sure they were pretty shocked to receive that bill. But in all honesty, that guy should be paid for his time. To me, that's my humble opinion, and I'm going to stick with it, but that's the way I feel. No, I'm not. Let me play something in my ears and see if it happens now. I've got something playing. It's cutting in and out now. Testing, testing. Testing, testing. Is it happening now? Y'all, my son is an M&M thief. Okay. Is it cutting out now? All right. So I wasn't playing anything then, but I will keep that in mind. Okay. So I want to talk about the federal investigation and some of the questions everybody's been talking about. It has been reported, and I said it this morning, it has been reported that the federal or FBI have stated that they have closed their investigation against Canton PD. And I kind of find it strange. I was so caught off guard yesterday that I didn't really think. I didn't click, but caught me off guard yesterday. But more I thought about, I'm like, wait a minute, but that doesn't sound like the FBI. That is not how the FBI usually works. So I'm waiting for more confirmation on that. I'm not sure really as to the validity of that. Is it a possibility that they have closed a part of their investigation? Yes. Could they have basically said, we are no longer, or they could have put a pause on it until this is over. But once again, even if they've closed that investigation, doesn't mean another one won't open after this case is over. So I'm not going to give up on the feds just yet. I did find it disheartening, though, that the Commonwealth is winning, and I'm sorry, the defense is not winning any of the motion hearings, that none of them are being granted. All the motions are being denied. And the only motions so far that were not denied were the motions that came under agreement to the fact that both the prosecution and the defense agreed to do X, Y, and Z. So for me, that's where I'm just like, dang it. We need something to go right for Karen Read right now, because that picture right there is worth 1,000 words. It is a heavy day. And I am so glad that this attorney is standing up there and speaking for the entire law firm. I think that it comes across better. I think if Jackson got up there and was trying to defend himself, it would not bode as well, in my humble opinion. That is exactly right, Haley Mouse. So in reality, the feds had hired ARCA. ARCA was being paid by the feds, but feds are not going to pay for them to come and testify in this trial. So when they didn't get paid by the feds, then they turned around and charged Karen Read. That is very plausible. I thought about that last night. Thank you for jogging my memory. That's when I started breathing a little easier last night. So that's what's hard about bringing in somebody to testify who was hired by a third party, and that's driving me crazy, who was hired by a third party to do an investigation or do work that affects or is involving this trial, who's paying them. And so I honestly think that Brennan is playing dirty pool here, and Brennan has succeeded, even if nothing negative comes out of this situation. Meaning, Auntie Bev says, "Okay, I don't feel that you've broken the Rule 14. We can proceed." It's devastating the defense because they had to take a week out of their trial prep to defend Mr. Johnson and the defense team. So, in my humble opinion, this is a bunch of BS. Let's see. And that was the other thing. The defense team did turn over their information to the prosecution. I really So I'm really struggling with that because I think that Auntie Bev should give a little hand smack to the prosecution. Mr. Brennan should get his hand smacked for misrepresenting the facts, because that's exactly what he did. He misrepresented the facts. It was like he walked up to the hornet's nest and he shook that hornet's nest, and then he goes, "Oops, my bad. Let me put you back up there. I didn't mean to touch it. My bad." And now Auntie Bev, being the queen hornet, is shooken and not happy. She has come into this courtroom at every opportunity with a chip on her shoulder. I think he's playing dirty pool wherever he can. See, this is a game of chess, y'all, to them. You move here, I move here, you move there, I move here, you move here, I move there, back, forth, back and forth. Well, the problem with that is that's normal, but he tried to make a Trump move, and he's trying to get rid of all of their witnesses. He's done it with Dr. Russell, who's a really good witness for them. I think that if Dr. Russell is brought on the stand, and now that she has been voir dired twice and she's testified once, I think that she is going to be a very credible witness for them. Now, once again, let's remember that I'm trying to get things organized. Let's remember that Dr. Russell, has such high qualifications that he is trying to get her knocked down, and that's what he did earlier, he being Brennan. And I keep saying Auntie Bev. Dr. Russell went to med school. So she's got an MD. She was a police officer for a while while she took care of her mother, who was ill. What did you get? What is this? Okay. And he got me a hot dog. I don't eat that much of it. That's good. Dr. Russell has pathology. She's got forensic. She worked in the emergency room. Out of all of the doctors that's going to see the most amount of dog bites is going to be an ER doctor. He is a good son. He's an amazing son. ER doctors are the number one, the doctors who are going to see the most dog bites out of any doctor out there. In fact, when I was dating my husband, I had 2 flying squirrels, and they were pets. I rescued them, and then they became pets. And I didn't know they were male and female. I thought they were 2 females. Well, come to find out they were male and female, and the female got pregnant. But one day I reached in, and she would hop on my hand and climb up all over me, and it was great. Kind of like a sugar glider. And She bit me clear through my thumb, back here and through here. And in fact, if I push hard enough, it's still uncomfortable. 25 years later. And I went to the ER because I think I was afraid that that bone that's right there was going to be broken. And it was like crunched. Then they could let it just heal. So sometimes in the cold, that thumb hurts. But anyway, while I'm there and they took x-rays and I'm waiting, this doctor comes in. Oh my God, I'm a bite guy. I love dog bites. I love animal bites. I've never seen a flying squirrel bite. Let me look. So we looked at the x-rays and he's looking and he measured and he goes, I'm documenting, I'm doing this big study on bites or whatever. And so ER doctors are going to be your number one doctors for bites. They are. And so then we get to the dog bite on the arm and we have the canine trainer to testify about dog bites. Canine trainers are not necessarily good people to testify on the dog bites. Some trainers get bit, some trainers don't, but also I'm pulling up something, y'all, so I know I'm looking around. My screen decided to move all of my folders around. Sometimes I come in here and the folders are everywhere. Let me pull it up in Canva. I did something. I kind of manipulated the dog bite photo or the arm of John O'Keefe. I manipulated his arm because I wanted to see if I manipulated it, if it would look a certain way. So let's see if I can find it. Yeah, I can. Excuse me. I'm going to share this screen. Okay, here we are in Canva. Let's see if I can make it biggen. There we go. And I was trying to see if the arm is bent in this position, how do all these match up? And so what I think I'll do is I'm going to go more this way so you guys can get a better view. This is the bicep and okay. This is what I want you guys to see. Let me see if I can embiggen this and keep it in proportion. 1, 2, 3, 4, 5. Okay. So this is being the wrist is going to stick out further than over here is the shoulder. If the arm is in a curled up position, like you're defending yourself like this, see how the wrists and all this, so this is the bottom, would be bottom, this would be the top. These two marks here, this is definitely a canine in Dr. Russell's humble opinion. Dr. Russell's humble opinion. You have a canine and a canine, and then you have, the side teeth. Or could be a double bite. It looks like to me a double bite. You got to bite there, bite there, bite there, bite there. So he kind of went like that. You got to puncture here, puncture here, puncture here, puncture here. If you draw that out, this outside to that outside, this outside to that outside, and this is coming in and that's going in. It looks like something has gone like this. It's this. When everybody's looking at these photos, the arm is stretched out. Let's bend it and see what it looks like. What do y'all think about this? Yes, they did. But he's not scientific. Once again, the method is what they're going to question. I love the video, Haley. Don't get me wrong. I love the video and I don't disagree with it. But the scientific method will be hammered by the prosecution. And I don't know if it will get past that. But if you just bend this like you're bending the arm together, like he's defending himself, and the dog jumps and does this, that is right. That's why it's not so deep. But do you see what I see? if you bend the arm, y'all. Let's stay on the arm bend. You see puncture, both here and here. Let me see if I can get a little arrow. Come on. I'm trying to get something that's colorful that I can reproduce. Okay, we'll do that. Let me make it small. Okay, you have puncture here. You have a second puncture right there. You see that little hole there? You have, come on. Why are you giving me hell today? I am clicked. Okay, you have another puncture here. You have another puncture here. Those are clear punctures. That looks like 2 bites to me. So I did 4 more. You've got punctures coming down here. Let me flip that. Come on. I wish you would let me do it. So you got a puncture here. You got a puncture here. And let me flip it. You have yet another puncture kind of, well, down there. These are other scratches. This to me looks like claw. Let me do this. That there to me with a bigger arrow looks like a claw mark. And you know what I'm saying? So I'm seeing a larger upper mouth on the bicep, a smaller upper mouth on the forearm. That's just my humble opinion. You can disagree with me if you'd like. But if you look at it with the arm bent, which is where it would most likely be in a bent position, I really think that this is a dog bite. But they're not giving that kind of a visual for the jury. The jury needs visuals and exhibitees, get more understanding, and it's easier to people to wrap their head around like what I just did. Not that it's perfect. It's not perfect, and I'm not an expert. I'm hypothesizing. And Sensei, get your butt out of there. Really? I don't know what's going on with her, but she's super clingy the last couple of days. Come here. You can lay there. Go ahead. Go lay in your bed. Go place. What? I haven't eaten yet. I've got to wait till they come back to eat. Ah. Thank you. They all said you're a good son. See? Oh, Matt's a good son. Oh, God, don't give me more. So, anyway. And that's true. The material of hoodies, it being loose fitted, makes it harder for them to get a good grip. Don't deny that one bit. So, they have the best fries, y'all. Or even good cold. How many fries do you know places you can eat cold fries from that are not soggy and nasty? This place. Okay. I know some people don't agree with me on that, but that's okay. I look at both sides of the coin. I'm here to play the devil's advocate as much as possible. But I do think that the situation with the elbow, though, into the taillight is definitely a no bueno. Not going to happen. Never happened, because you would have broken glass on the bottom of the elbow. You'd have it all the way around. You'd have scratches, not just on the top part, but all of it. Okay, it looks like they're trying to come back into court. Tanika put up our oh, crap. Really? So, sorry about that. I'm emailing Miss Tanika because the video, yeah, these fries don't get soggy. That's one thing I love about them. And if you want to warm them up, you just put them on a little oven, put them in the oven, and they just warm up and stay crisp. They don't get soggy. They so good.
Please.
Sorry. Can you get the video that she had together for her channel? Mm. Excuse me. Sorry. I'm getting really hungry. The fan is on high today, so we can tell they- that was a good job. Paint the ceiling. Okay, so the fan is on proverbial high. The fan is on high. I wonder, did they give it Red Bull to make it fly? Did it give it wings? Um, I really wish that they would just focus on the seal because honestly, looking at that fan, I mean, just looking at the camera with that fan going, I just want to go. I just want to block it from all of my sources. It kind of makes me nauseated because I have the fan moving in front of me, fan moving at 11 o'clock, a fan moving at 1 o'clock and at 4 o'clock over here. Oh, for those of you who don't know, hi, there's my setup. Oh, not the best view. Let me re-engage this because I don't like to get the camera. I don't like to get the the light from there we go. I got to set it. I don't like to get the light the hot light on me because it's hard for y'all to see all this. So anywho, that's where we are, y'all. That's where we are. We got the I liked giveaway over here. Make sure that you like my video in YouTube. If you are on X or any other format, please go on over to YouTube, even for a moment. Hit the like button in YouTube. Comment liked, like this, hit like that. We only got 5 entries right now. You will be entered into a drawing for a $50 gift card. That is going to be happening at the end of the month. We have the last month's winner is said to donate it to somebody. So I will let that person know who is the recipient of that donation. And I will find out where they want their gift card to. So yay. Yay. I will go to Discord right now, my love. My lovely. Did you send it in message? Oh, thank you. I saw the bell go, but I'm waiting for Judge to come back in. And once she starts, it'll be different. Oh, I saw the bell. Drink. Hydration is very important here. Okay, this just coming in live from Olivia via Angela. Breaking sources. Breaking news. Sources say the only thing Hank Brennan is eating for lunch is his words as he desperately calls around looking for a top shelf professional responsibility lawyer. Ladies and gentlemen, Rule 3.3A-1, candor towards the tribunal has entered the chat, and it ain't looking good for Hank Brennan. Yes. A lawyer shall not knowingly. Oh, I got to read this. Okay, Auntie Bev, you're on pause for a second. Well, I guess I can't do that. A lawyer may not make a false statement or fact or law to rebuttal or fail to correct a false statement. Okay, well, he corrected it. He did come back and corrected it, y'all. So we're good with that. All right, Auntie Bev is back. I'm really not liking this one.
Thank you, Your Honor.
Okay, let me get back here.
May it please the court, I first want to thank Your Honor for the generous amount of time you're
No
according
need
me.
to thank me. Just go right ahead, sir. And take your time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, "Hi, Alan, subsequent to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote the,
Here.
and it's good to have it, Your Honor, can be having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email,
Yes.
and because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57.
So he did not. So he did
Now
not.
back to page 60, or excuse me, back to page 58. And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, touring requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications, that's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery?
And you told me the 12th.
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try my best. I may get something wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay.
All right.
And so it suffices it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And
Do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
And I'm understanding Your Honor would like me to pause until you get
Judge,
that.
if we can, because I'm looking at a
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
I think it's approximately 6:30 in the evening. It was received by the Commonwealth
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So
You just nearly
also,
Look.
in big bold letters, at least on the printout, the subject is Karen Reed ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just
So what he's saying, it's very clear what we sent and what was in that file. A lot of times, if lawyers are sending all their evidence in discovery, and there's something that could potentially hurt them, but they have to send it, a lot of times they will bury it within, you may have a file that's labeled vehicle photos, and then you have another file that says so and so witness testimony and doctor's reports and hospital da 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 da. And there is a comment from a physician that states that they do not believe that this is how this accident happened or whatever, and they want to hide that. They're going to take that report from the doctor and bury it within the reports of something that may not be related, like pictures of the car wreck. I'm giving a very general thing. So they can bury evidence, because if they're sending over, they used to do it paper. Digitally, it's not so hard. I mean, it's to find it. But back in the day, when they used to do everything on paper, and they would send the evidence over to attorneys in boxes with reams of paper, we're talking 8,000 to 10,000 pages of papers at a time. And they would take that one report and bury it in the papers randomly in a different file. So that's where he's getting to the word buried, because that is legal to do. You gave it to him. You could just take all the papers and throw them up in the air, gather them up and hand it to him. You do not have to give it to him in any order or any kind of labels or anything. You could just hand them papers just in a hot mess. And they do that in some trials. In fact, I think they did do that in the O.J. Simpson trial. So that's why he's using the word buried. It's a phrase. He's saying, look, it wasn't hidden. It was not hidden within a bunch of other paperwork. This email said, ARCA, this was very clear what you were getting. No misunderstandings what was in that file.
Just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the
It
answer.
was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one, I'll pick perhaps the most probative one. I'm not gonna refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure
I
you,
have it.
thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah, so
Subject-
that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was gonna get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor,
All right,
and I
so
appreciate the question.
What
So
is the date of the, so you're saying what I refer to as the script was sent on the 23rd?
that is correct, Your Honor.
What was the other one? When
The other
that
one was
sent?
sent the day before on June 22nd.
Okay.
I'm just gonna give the name that the email has. I think it's wolf_quals document, okay? So there's two emails, one's just the quals, the other, I respectfully, Your Honor, I know what you're calling it. I'm just gonna call it what it says, and the title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email.
Okay.
The last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
I'm gonna
just
actually
went.
hold that thought. I just have one other thought. about
Yes,
this. So
please.
We're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you are
correct.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
That, I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate,
Okay.
and I'm gonna get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less than blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago, 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down the roadway, et cetera, et cetera. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have, I agree, it would have been, and you did. Twice. Next. Reading on the same page 16, he's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice. In the voir dire and in the direct. In the direct, it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say or not? And honorably, Mr. Jackson, nope, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry. There's another point at the No, let's go if we could. I don't want to take the lesser significant ones. I want to focus, because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2. And then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases. I've been around the federal court a bit. I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried among several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something.
Right, Angela?
There is no statement about the date of the invoice on February the 18th. So people are left to wonder.
I agree.
When did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made. Sometimes parties pick sides, it creates blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion. It's a statement of fact. Statement about federal investigations that were there. These are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it as, you're preventing us from getting this information.
I bet he's seeing Auntie Bev's body language and he's learning when she does, he's reading her while he's talking. So he's going, I'm not going any further. I got your body language. We're good. I'm moving along.
Defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and frankly of the moment in this trial. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this, the court saying the break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case?
No,
Or
I'm
you saying
talking
generally, you've had this issue in other cases, or do you mean?
other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break. So we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court. I might have asked for a sidebar and come up and said, Your Honor, my bad. This is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARPA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARPA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government, it was the defense. February 13th, they sent us the emails in the direct examination outline. I think I said, that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14, what was not corrected? It wasn't corrected that the invoice came from the defense. Just emails.
I thought it meant everything, but.
I don't understand how that conclusion can be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
Because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact.
And both he and his son both agree that this is not, they do not believe, or if I'm stated, someone tell me, but if I understood it right, from what I heard, is that that they believe that this may not be over. They're not, at the time I heard it, they were not sure that the investigation was completed. So I'm waiting to see what they say as well, because his dad is the expert.
To a court. The second part of 3.3A1 is you get the opportunity to correct, and you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I separate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this, being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended, but that parties could contact ARPA. Obviously, the Commonwealth is in no position to contact ARPA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them. Yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARPA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that, because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court that isn't accurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize Your Honor's giving us that week, and we try to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move rather hopefully efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because Your Honor brought up
Again,
some.
you don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to
this poor guy is so analytical, and he is so thorough, and he wants to make sure everything is precise, perfect, clear. And she's like, just get on with it. Dude, you're doing a good job. I know, right? Now she's going to get irritated. Let's see if his tail's between his legs today. Let's see what happens.
Model Rule 3.3A1. And this applies to every counsel in this room, of course. A, A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of making a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th, there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses, and that is why I spoke about Mr. Yannetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said. Or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What
you.
page you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the 2 prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalfin, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor, obviously, has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court, move to exclude the witnesses? Mr. Brennan, yes. The court, what do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court, I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important, the court, if I don't exclude it with other sides seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided, the federal authorities provided all the discovery that was intended to their analysis and testimony. So What we have in terms, Your Honor, this is important, I'm going to go right back to 3.3A. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided before, well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the quals, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when. And so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances, and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements, and she made misstatements of fact about the financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In some, Mr. Yannetti's statements on June 10th, all completely accurate, Mr. Jackson's eliciting of the direct testimony at trial when he asked, have I ever asked you specific, questions, etc. That's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, et cetera, and what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry. Okay. So my point is, we produced the discovery.
Repeat it. We heard you.
Why is there still an issue with ARCA? These aren't my words.
Wow.
So I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it? The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the
Was
U.S.
that
Supreme
counsel pro hoc vice, or was that?
I'm going to get to that. The answer is
I couldn't remember how to say it.
the counsel. I want to be sure my answer.
I had a really hard time saying it because it's not spelled the way it said. Pro hoc vice. Pro hoc vice. There it is.
Yes. And I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in, it wasn't a revocation of pro hoc vice, there's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so, the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th? There were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say this as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can and certainly can.
Gee,
Thank you.
I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All rise.
Whoa! Auntie Bev really must had to get to that bathroom. It was like boom. That was a boom. I have a cool drop mic sound, but I don't have it on the machine that you can hear it. Well, oh, that's. Oh, it's not on here.
When all else fails, read the instructions.
That's kind of what I wanted to say at some of this point. Here is. That's Brennan. That's Mr. Brennan. No. Okay, guys, if y'all know who Tanika is, she has posted, and I'm going to get the live feed and share it with you. I was a guest on one of her lives, and it was pre-recorded. Share, copy link. Now I can put it in here. Here is the link. And I've got to learn not to look at comments from people after I do something. They're 99% really kind and nice. So that's awesome. But she did a wonderful job putting this together, and I want y'all to see it. Go love on her a little bit. But yeah, I thoroughly enjoyed being on her podcast, her show. Yeah, yes. Somebody made the comment about, I appreciate you covering this. That said, please don't let this expert, they put me in parentheses, or any other that you have here say the children's names. Look at what the community has already done to the victims of the family. I 100% agree. The kid had nothing to do with the crime, but I can bet you now that other experts have done so. Guys, I don't like saying kids' names, and so just know that I will never use these children's names at all in this case. I don't think it's fair. Once they're adults, that's a whole nother thing. I will go in there now. I'll put in members chat. But I will say, oh, what is it? I don't want to say it. Oh, hold on. There, got it. Want you to do what? But I've already got it. It was a copy and paste for me. But I'm not an expert. I'm telling you what I know.
I did have a serious dive into this case. I know a lot about this case. Someone said that I'm definitely on the side of Karen Reed. After watching this trial, now when I came into this trial, I knew nothing. I was looking at it like an alternate juror. I knew nothing about the trial. The only thing I knew of the trial when the trial was going on was what was presented in court. And that, where is that? I'm getting a light coming through on my backdrop and I don't know where it is. Is it low? I don't know. Yep, there it is. Maybe that fixed it. Yep. But anyway, by the end of the trial, I had already made my decision she was not guilty as a juror, because I didn't look at anything else. So, in my humble opinion, after watching that first trial, if I was on the jury, I would have said not guilty all the way across. That is my humble opinion. And I have the right to defend it, explain it, and say it as anybody else does. I'm not an expert. I was not proffered. I didn't have a voir dire. Anyone with a brain knows a brain is on KR's side. Well, then there's a lot of brainless people. But you guys go on over to Tanika's 2 cents. I dropped the link up above. I dropped it in Discord in member chat. And go love on her. She's amazing. I hope to have her on Sunday for the Adelson trial, and she's going to come on my page, and we're going to go live with that. Hopefully. I forgot to remind her. Hopefully. Reply. I think that's what we were going to talk about. I did switch tops because I was hot on the upper and cold on the lower. I'm going to be cold, it's going to be equal. And my deaf person notified me that they're not going to be able to be on today, so I don't have to be in black. Okay, I want this little quick break. You guys, please, in a few short words, give me your opinion of what you've heard. The question is, maybe I should do it this way. I forget I can do this, y'all. I forget. I forgot. I can do this. Start a question and answer. Okay. I got a question. I forget we can do questions. So we've started a question. Send. We've started a question. We do need to cover the Simatilli trial because there's getting some pretty interesting people up there. So I might do Simatilli tonight to catch us up. Oh.
Crazy in Canton. Top 5 Karen Reed questions answered by special guest Ada K. Thank you, Miss Tanika. You are such a wonderful person. Do you know that? Do you know that? And do you know what? I'm going to click like on that where the guy said, she's pro Karen. Boy, she knows everything about Karen and she knows and about the dog. No, I don't know everything about Karen. There are people, Brandy at juror number 13 knows, or the 13th juror, excuse me, knows far more than I do about it, but I absolutely know a lot. And I was a dog groomer. I've been a first responder. I have seen bites on my end when I've been bitten a lot. And I have also seen it when we've had to haul people to the hospital. So, I mean, I'm not saying I know more than a doctor, by no means. But do I have some more experience than the common Joe? Maybe, when it comes to certain things. And I will say this, I don't talk about something unless I know that what I'm saying is correct. And if I do misspeak, I apologize and I go in and learn a whole lot more before I ever speak about it again. Just saying. So, but I am so blessed to have all of y'all here. You are amazing people. And we got this proverbial fan that is driving me crazy. I'm going to have to get it off screen, y'all. It's making me nauseated. I apologize, but it is making me nauseated. I can't do it. So, I'm going to X and see what everybody on X is saying. Jeff Cahoney, want to call him Cahoney. Jeff Cannoni wouldn't really like Jackson off of this case. No, she really wouldn't throw him off of the case, would she? This is lawyer, you know. I just can't imagine it happening. Talking about going viral, some of her questions seem like that's the way she's leaning, but it can be. That was lawyer, you know. By the way, the White House press is really stirring things up. You need to. And then somebody else says, absolute bombshell, the slimy Karen Reed defense paid ARCA. Busted, not just for travel expenses. Well, you know what? I think Haley Mouse is right. I think they sent the bill on to the feds and the feds said, this isn't our bill. Oh my God. I just saw something a guy is doing with the lead shooter and he is so unsafe. I want to send this. Oh, I want to send this to email to myself. I'm going to send this to Ian. I'm sending this to Ian. I want his opinion. Send. I want Ian's opinion on this. I saw something really horrendous. He's going to have a conniption. He's going to have a conniption. There's a video of a guy trying to teach a woman how to use a oh no. I can show you this. I can show you this. Look at this. You want to talk about new? Oh my God, this is not good for crime. Watch this, y'all. Just make sure you have your little sister from them. They tell me Chuck don't. I'm going to get caught on that. Watch this, y'all. This mask is insane. Oh, you're damn straight it will be an appeal. Watch this. Oh, look at that mask. So he can go and commit a crime and
Are y'all seeing that? Oh my gosh. OMG. OMG. I saw that and all I can think was how criminals are going to start using that and getting away with oh y'all, you want to see something amazing? I'm showing stuff. See this. Hold on. You want to see how lucky this girl is? Watch again. Dang. Okay. She's back in court. Back in the saddle again.
Questions. Other counsel. So while memories are fresh, I just want to ensure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know.
No, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after I looked at the transcript.
No,
I
no,
did as well
no,
after
no.
I looked at the transcript.
I did long before I looked at the
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small.
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is.
Nope, hold on. Ms. Little, it's just thrown on you that you're responsible for all discovery. But the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay, so I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
30 minutes.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense.
By the way, Ian Runkle of the Bailey says, "Oh shite! I can't." Says Alessi is coming after the fair trial implications of the Judge Cannoni's statements. Sounds like I may be pitching for a mistrial with prejudice. Runkle of the Bailey.
The first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They posture the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARPA was not wholly independent. It's information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alisi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanche started is not enough. This isn't just about Rule 14. My effort with the ARPA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them, and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations at the sidewalk. And those questions were right to the point. And when we were sidebar, specifically mentioned, I don't know, a voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARPA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARPA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARPA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Alisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Reeves.
It wasn't a request, Your Honor.
You said-
Whoa, let's hear that
We
again.
did not hear a word from any of them. According to Mr. Alisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Reeves.
It wasn't a request, Your Honor.
You suggested that I call.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that the defense
Oh,
was
look at
given
the
the
face.
opportunity.
Okay, I want to go
bring
back and
forth.
do that again.
I do that, Mr. Reeves.
It
Who was
wasn't a
speaking?
request, Your Honor.
You suggested that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is, it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to
That is
clarify the
true.
record. Instead,
That is true.
it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that Archer's position did not change, it did change. Their opinions did change by the time they reached
Yeah, he
trial.
responded.
It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. It doesn't help the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents were provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not correctly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider Pro Hoc Vice. We have one licensed attorney in Massachusetts who's carrying 3 Pro Hoc Vice attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Annetti, a fine attorney, an excellent attorney who I admire, but there's a responsibility so that there are not a number of Pro Hoc Vice lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge essentially of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask co-counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please. All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've done.
May I have a moment to speak to counsel?
Sure.
Thank you, Ron.
I'll need to call the United States Attorney's Office and get an answer.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the board here, where it was asked, were you available to the Commonwealth? And the witness said, yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number to the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi.
The song, I have nothing. If I don't have you, Whitney Houston just went off in my head when as soon as he said, I have nothing. It just boing, went off in my head. Now I can't get that song out of my head.
Suggesting somehow that this was open and notorious is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, this is June 10, 2024, trial transcript 28.
Hold on one second.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when we look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18, 2024, the voir dire hearing. The court asks, well, I thought that you would help.
I've got the transcript. What page you want? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up. Page 4, line 11, the court asks, so the understanding of the voir dire is that if this is for the Commonwealth's motion to exclude this testimony, all right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able you haven't been able to even talk to them at all about this case? And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71. Okay. Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked in the court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect
Sorry, guys, had to go get the door.
commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions, voir dire, and at trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024, it's addressed to.
Hold on 1 second, please.
I doubt.
It's addressed to Attorney Jackson, and the position that the defense takes, Attorney Lisa
Have you
takes,
noticed-
this came out of the blue that they had to pay.
Have you noticed her tone with the prosecution versus her tone with the defense? Just saying.
Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCA experts knew, Dr. Wolf knew, Dr. Rentschler apparently knew, the federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in the telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communication.
22nd, not 22nd. She corrects. Y'all, have y'all noticed this?
Because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there was a June 9, 2024 phone call. Another participated telephone call with Allen. And then we see before.
I got to show y'all this. Ada Kearney. Helena Raftery showed up in court today with Paul and Peggy O'Keefe. She left 30 minutes later. We had a stare down on her way out of court. Aaron O'Keefe is not here today. Can't imagine why. Are you ready for this? Y'all want to see this? Thank you. This is Turtle Boy. Oh, this is a trial, not a dating app. Massachusetts. The Commonwealth fancies facts like Paul fancies donuts. Oh, Turtle Boy, thank you so much for that comic relief. We needed it. Okay, back to the wah, 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 wah.
The voir dire testimony, there is billing to the defense.
Thank you for the person
Now,
that didn't want to be told. Someone's gonna-
Prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and the court never knows about. Talk about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation, nothing. Nothing. And so, when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story, a fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality,
Look at that face.
we also, at some point, we're going to address
That's boredom. That's like, I gotta stay awake. I gotta stay awake. So I'm gonna start rocking. I'm gonna stay awake. I'm gonna start rocking. She's kind of. Bev, you did it to yourself, honey boo.
the Commonwealth position of violations.
Honey boo, you did it to yourself.
It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did they?
Particular page you'd like to look at without site.
If you look at the first page.
Yes.
Yeah, well,
You don't have to read any of it, you just tell me the paragraph.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we'd be oblivious if we stood here and said that the relationship between the defense and the experts, there was no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARPA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARPA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works.
I'm not trying to be mean,
And
but
so,
I'm like,
we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with our experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled.
wait a minute. You're sitting here saying you may not have everything. What about the defense? When? I mean, the defense has had to fight to get evidence from you. You're not, oh, all I hear is a crying baby. I don't hear logic. No one really ever has 100%.
Your Honor has mentioned the sidebar.
Which one?
Unless you have a video like with Sarah Boone, there's.
I am not trying to be overly critical of another attorney. I'm not.
Yeah, you are.
You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARPA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
He reminds me.
Mr. Leslie, very
He sounded defeated. Did he not sounded defeated? He sounds defeated.
briefly if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points.
Please. And everyone else is right.
Attorney Brennan focused a lot on the invoice.
He looks exhausted.
As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That's a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about because what he said, that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different.
Jackson's looking at him like, dude, you better get this shit right.
From what you've heard in court today, and it wasn't. It's important.
Do I have to? Oh, shoot. Really?
Never spoken to, and not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant or choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Very briefly.
Oh, look at him. Ooh. Ooh. Oh, love it.
My arguments in the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed late, right?
February
Or
6th.
Saturday or something.
February 16, 2025. This sums it up, really.
I love it.
And this is signed by Attorney Jackson,
Now, my favorite
Attorney
phrase.
Lisi, Attorney Minetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not.
Ms.
right?
Little has
It's
only done the
maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Minetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC.
I know, right?
And Daniel PhD and Andrew Rentler PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Lisi no longer likes the word retain, but that retain word has import. There's a reason he said it. Their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay.
What time?
All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
Tuesday. Tuesday, Wednesday, and Friday. That's 8 o'clock my time. If you notice how quickly the O'Keefe family gets out of there. The O'Keefes are like, we're gone. Yeah. Wow. Okay, so I got that on the calendar. OMG, y'all. What do you think? I really struggled with the prosecution. I really struggled with the prosecution. I don't like the prosecution. Crazy. It's like, okay, I was hoping to get somebody's opinion, but we are too far behind. It is only 3:30 here ish. So for now, we're going to go back to the Simatilli trial for a brain cleanse. Because I need a brain cleanse, and I don't have anything to do for the rest of the day. So let's go ahead and go back over to the Simatilli trial. It will give me a minute to be able to let my brain absorb, and then we'll talk. I will say, I think the prosecution had a far better possibility. I mean, they were prosecution, which is not surprising me with this attorney, was super organized. I felt, and of course, I'm the type who goes by my feelings a lot. I'm not as analytical as some people are, but I felt when I looked at the prosecution, his confidence, he seemed more defeated today. He didn't have the confidence he had the other day. So I kind of think he knows he's kind of opened up a can of whoop ass, and the ass whooping may not be the defense. It may be his. I don't know. We will be, of course, keeping our ears to the ground for professional attorneys' opinions. But once again, their opinions are the opinion of the layperson. Sometimes it's just as important as the lawyers, because I'm going to tell you, the jury does subconsciously take into account how they feel about the person presenting the case. If you feel like a snake, they're not gonna respect you as much. It kind of blurred, especially on the prosecution side. I did appreciate the fact that he did, the defense had a very good, clean outline and a path to follow. I wish I had a copy of that, but it looked like it was massive. And so anyway, so with that, everybody, we're going to hop on over to the Simatilli trial now. Day 17.
Anything further?
No, thank you.
Thank you, Ms. Truesdale. You are excused. Hey, call your next witness.
People called Detective Dave Frederick.
Come on, guys. If you liked please do the I likey thing. I find it interesting that when the witnesses get off the stand, a lot of times they lean over and say something to the prosecution. That doesn't always look good or bode well for for somebody when you got a jury sitting right there.
Your
I was assigned to Robbery Homicide Division.
with the LA.
Or that 5-second really is a 10-second jump.
And for the record, say and spell your first and last name, please.
My first name is David, D-A-V-I-D, last of Frederick, F-R-I-E-D-R-I-C-H.
Seat, please.
Thank you. Sir, are you currently employed?
I am.
Okay, and how are you employed now?
I work for a technological company, a camera company.
Doing security?
Yes,
Okay. And prior to that, did you have employment for many years with the LAPD?
I did.
Okay. How many years?
A little over 30 and a half years with the Los Angeles Police Department.
And what was your last assignment at the LAPD?
I was assigned to Robbery Homicide Division, assigned to a plainclothes tactical surveillance unit called SIS, otherwise known as Special Investigation Section.
For how many years were you in an undercover capacity?
I was in SIS for a little over 20 years.
I want to ask you about your surveillance work on this case regarding the defendant, Monica Cementilli. Were you asked by detectives at Robbery Homicide Division to conduct a surveillance operation along with your team with respect to the defendant and her lover, Robert Baker?
Yes,
And were you briefed on March 9th of 2017 by Detective Corbin Rowe regarding the operation that was going to take place that day?
yes,
And at that time, were you, along with the other team members, provided with photographs of the two targets?
yes,
And do you see the defendant, Monica Cementilli, who you surveilled on various occasions here in court today?
I do.
Can you identify her, please?
She's sitting in the defense counsel wearing a blue jacket with a light blue shirt.
Indicating the defendant.
Showing you People's 14. Do you recognize the individual that you see here?
I do.
This is in People's 14. It has a red 2, Your Honor, in the bottom left corner. And who is that individual?
It's Mr. Robert Baker.
Who is the second target in this case?
Yes,
And were you also briefed on vehicles that the two targets might be driving?
yes,
Okay. Was one of those vehicles?
I'm just going to say this. If you look at the report that ARCA did back in February, was it February? I'm going to say February, back before the trial. And then what he testified to and what's happening, it's consistent. Nothing is inconsistent. They have been consistent. And I think Haley Mouse hit on it. I think that the ARCA people, because it was July before they billed, which surprised Karen Reed's defense team, I think they may have tried to get paid by the FBI, and the FBI said, I'm sorry, boo-boo, you were in their case, not ours. We are not paying you. Then they sent a bill over to Karen Reed's team. I don't see any problem with it. I don't think that they lied at the time. They hadn't at the time. And even if they planned to pay for certain expenses, that's not paying for testimony. That's covering the cost. And there's a lot of experts that have come in as an expert and said, I don't care what side I'm here for. I don't care who called me. This is the facts. This is the way it is. You're not going to change me, defense or prosecution. I'm here to give you the scientific fact of whatever that is. And somebody's going to pay me for my time. End of discussion. I think Brennan is a slimy, sneaky, underhanded lawyer, and I don't like him. What he's doing is hampering the defense's ability by taking up all their time on this. And I got to tell you, I felt bad for Jackson to have to sit there and listen to all this, and it's hard not to get up and defend yourself. It really is. But I think they did the right thing by him not speaking on any of it. It's like the lawyer had a lawyer, and that was a good move. Very good move. Now, Auntie Bev is going to make us wait a week. Dang nabbit. All y'all out there, my mods, if anybody gets any paperwork on this, any decisions on this, please make sure I see it. I'll still be looking, and if I find it, I'll give it to you.
Expedition belonging to Robert Baker, as seen here in Exhibit 142.
Yes.
On that same day, Thursday, March 9th of 2017, somewhere around 7:20 at night, were you and other individuals, including Rich Guzman, working a surveillance operation regarding the defendant and Robert Baker?
Yes.
And where were you at approximately 7:20 that night when you were setting up for this operation?
On that night, I was parked on the southwest corner of Van Owen and Independence in a parking lot. We were covering a direction from the surveillance.
So that would have been very near the location where Robert Baker was living.
I'm sorry. I love this. I feel that Elsie did a great job in laying out his argument in a very logical way. My only concern is he did go on long and start the judge to zone out. I'm sorry, that judge zones out after 3 minutes. Are you kidding me? I can see her brain on the inside. You got one man over here starting to fall asleep. The other man over here smacking him and telling him to wake up. No, I think she was listening, but yeah. I would like to know what the consequences could actually be. Legitimate consequences, not what people hypothesize. I want to hear from a lawyer in that area and tell me what could these consequences actually be.
At 6817 Independence?
Yeah, I believe he lived north of Van Owen.
And so you were setting up in order to see where he went that night?
That's correct.
Okay. And at some point in time, did you receive information as to someone in the unit having eyes on him?
Yes.
Okay.
wasn't
And was
pointing
it
her
broadcast
glasses.
to you where he was going?
It was broadcast that a black F-150 pulled into the northeast corner of Van Owen and Independence.
Was that black Ford F-150 also a vehicle that you were briefed on as belonging to the defendant in this case, Monica Cementilli?
Yes.
And once you received information that she was driving the Ford F-150, what was the next piece of information you received?
If I recall, there was broadcast over the air that they were looking at bags in and around the vehicle.
It appears so. If you wish to make an offer, proof, let me see it sidebar, please.
I'm going to actually play video.
All right.
Subsequent to the broadcast was videotape obtained of both targets in a parking lot that you guys were also setting up on.
Yes.
Overruled.
Your Honor, I have two videos. The first one is a video of the petrol gas station. The second's going to be a video from LA Fitness. Both of them are on a flash drive that I'd like to, or I think it's previously marked as 158. We're going to add to that exhibit.
Good.
Is that the black Ford F-150 that you were advised of belonging to the defendant?
Yes,
And you've seen this video before, correct?
yes,
And the shopping bags that are being carried by Robert Baker that you also mentioned?
that's what was broadcast over the air.
And then what did you see, if you could narrate for us what we're looking at?
Well,
He
What-
just put the bags into the back seat behind the passenger?
that's
front
correct.
passenger?
Yes,
And then do you recognize the female?
it's Monica Sanatelli.
I
Here's
think that's
the
what they
photo
may.
of the passenger
I
door looking in the bags.
what I apologize.
Yes,
If I was a judge, I would contact the what was it, the lawyer association thing with that they said that the defense said they called and said, "Hey, this is what's happened. What do we do? Are we going to get in trouble? Do we need to pay it? Do we not have to pay it? What do we do?" And they told them they had to pay it, so they paid the bill. They need to call them and they need to call the ARCA. Although they had the copy of the emails, I don't know why they'd have to call ARCA, but we'll see. But she definitely does need to do some investigation.
Pulling out
Well,
items.
I can't trust Brennan on his own word.
So,
Not at all.
Holding up various items, is that what you see?
that's what I see.
Is this all
Aw.
consistent with what was being broadcast to you? And what you've seen on this video before?
Yes,
And during the time that this is happening, everything's being broadcast to you on a regular, repeat basis?
just important details that the person, whoever's on point, is broadcasting.
And you pass off point during the course of your operations, correct? Depending on the direction that they go and who is parked where.
Correct. Like in a mobile surveillance, it's not just me that sees everything. Everybody in the unit sees a little portion of the surveillance, and whoever's on point, who has the eye, broadcast the movements or direction as if, and if I'm listening to it in my head, I can almost see it in my head so I can make sure that I'm in the right spot in the surveillance to seamlessly get behind the vehicle or get on foot to watch them. That's how surveillance works. The idea is to watch a person, place, or thing, document, videotape, get some notes without being compromised.
It appears that they're both still at the back passenger door. The defendant's still holding up, pulling out various items from the bags, holding them up. And the two of them are conversing.
That's correct.
But why? What are you doing? Shopping out of your own closet?
Appears that the defendant has moved whatever jacket she was wearing now.
On the video, yes.
And then appears to be getting into that back passenger seat where the clothing bags were.
Yes.
And does it appear that Baker's going around the back of the vehicle to the driver's side?
Yes.
And again, at that point, was it broadcast to you and others on the team that night that they were moving?
Yes.
And at that point, did you follow them somewhere?
I stayed where I was at. I was still at Van Owen and Independence on the southwest corner. The vehicle actually pulled into the area where I was sitting at, kind of behind me. I was facing southbound, and the vehicle pulled up to my rear, if you will, kind of northeast of where I was parked at.
Okay. So you didn't need to move. You were already set up in a good location.
That's correct.
All right. And then that area, lot area.
Yeah, I believe it's an apartment complex with an open parking lot.
Okay. And what did you see once Baker drove in to that location?
I was with a partner. I wasn't just by myself. My partner was Detective Pete Miranda, Miranda. And I was driving and I was using my side view mirror to get the visual as well as turning my shoulder or turning my head to my left, looking back. But I saw Mr. Baker exit the driver's side and kind of walk out towards the right front of the vehicle, and see Monica Cementelli, and they were hugging and kissing. And then eventually I recall seeing them.
I forgot to put it back on.
inside of the
Or
portion of the vehicle,
y'all,
kind of
or
in
y'all.
my
She's
That's
changing into
exactly what they were
something else.
doing, but the
She
way their
went through all
bodies
the clothes.
were,
She made her
they were
decision. Now she's
definitely
in the back trying to change
embracing
into
each
those
other.
clothes. What do you think?
All right. And then did you follow somewhere?
From there, they loaded up. I believe Mr. Baker was still driving, and they drove away eastbound in the San Fernando Valley.
And at this point, did the defendant get into, prior to loading up and moving from that second parking lot, get into the right front passenger seat?
Yeah, I recall it was definitely the passenger side.
Okay. And where did you follow them to?
But the unit, my unit, and myself continued surveillance, and Monica Cementelli and Robert Baker end up going to the Good Bar Inn, or the Good Night Bar, in North Hollywood, I believe.
Okay. And did your partner get out at that point?
He was out on foot.
Okay. Just like you were describing earlier?
Correct.
Okay. And at some point in time after he followed them on foot, did you see the defendant along with Baker come out of the location?
I didn't see him come out. It was broadcast to me that they were walking out.
Okay.
I had already placed my vehicle on Denny Street. It's in North Hollywood. It runs north and south, just north of that east-west major. I was able to locate the truck to the rear of the bar, at least see the top of the truck. And I saw them walking northbound on the east sidewalk, holding hands prior to them getting into their vehicle.
Okay. And then did you follow them to another location?
Yeah, the surveillance continued, and I believe they ended up in West Hollywood area or Hollywood area to the Comedy Club.
And did you remain at that location till the end of watch?
That's correct.
All right. And they remained inside the location past when you ended your watch?
Correct. We had left the area and they were still inside the location.
All right. The following day, Friday, March 10th, at about 2 o'clock, were you once again part of a surveillance operation that SIS conducted with the same individuals?
Yes.
And on this particular day, did you go to a particular location based on trackers that have been previously placed?
I believe we located Mr. Baker and his black expedition on the southeast corner of Ventura and Winnetka.
And what did you observe at that time?
That he was alone eating in a like a Japanese restaurant in like the strip mall area. I believe there's a Ralph's in that parking lot.
And at that location, did you get out of the vehicle and install something on his vehicle?
I did.
What did you do?
I placed a GPS tracking device on his vehicle.
I want to move your attention forward now to Monday, June 5th of 2017. In the morning, once again, were you working on a surveillance operation that took place that day at the Queen Vic location?
Yes.
Her residence, 5012 Queen Victoria?
Yes.
Woodland Hills. And did you observe her, the defendant, driving that day?
I did.
And did you observe her actually leaving the residence?
Not actually leaving the residence. I believe it was kind of hard to set up a point on the residence. So I was down the street and covering the direction. And I observed Monica Santelli driving, I believe, a dark color Mustang.
And at this point, was this a new vehicle?
Yes.
Okay. Showing you it's been previously marked as People's 148. Is this the vehicle that you observed?
Yes.
And she was coming from the direction of her home towards where you were parked just down the street?
That's correct.
The next day, June 6th, once again, was a surveillance operation conducted that you were a part of.
Yes.
Okay. And in addition to the vehicle trackers that we've heard about, did you locate her that day from a phone ping?
Yes.
What's a phone ping?
Well, detectives can write search warrants for somebody's cell phone. Every 15 minutes, they would get a general location where it hits off a cell tower. That particular ping, I wasn't obtaining them, or I was not getting them from the phone company. I believe other detectives were. And it was broadcast that for us to look in the area of like Van Owen and Canoga area, I was able to pull into the LA Fitness parking lot on the southwest corner of, I believe it's Victory and Canoga.
Okay. And go ahead.
And located the black Ford Mustang in the lot facing southbound.
Okay. This is not a wiretap. It's a geolocation ping.
That's correct.
Information, correct?
Just a location to where it's hitting off the cell tower and puts you in a general area.
Okay. And so what is it that you were able to locate in the LA Fitness parking lot over at in Canoga? Is that 6401 Canoga Avenue in Woodland Hills?
And I believe so, yes.
Okay. And what did you locate?
I located the black Ford Mustang parked in the parking lot.
Okay. The same one that you had seen her driving the day before.
That's correct.
Okay.
Hi, beloved. Thank you
And
for joining us
when you
today.
got to that
As always,
particular
love you.
location, were you in a vehicle that day with a partner, or were you by yourself?
I believe I was by myself.
Your Honor, I have six photographs from the LA Fitness located at 6401 Canoga Avenue in Woodland Hills. May they be marked as the people's next in order?
197.
197?
Yes, so marked.
Thank you. Showing you what's been now marked as People's 197. There's a 29 in the lower left corner. Is this the location where you located the Mustang?
Yes, but on the far east end of this parking lot.
Okay. Showing you People's 197 that has a number 30 in the bottom left corner. Is there a large parking lot, as we see in these photographs, outside of this gym?
Yes,
Same location where you were set up that day?
yes,
Showing you exhibit 197 that has a number 31 in the lower left corner. Is this the Mustang that you located in the parking lot?
yes.
And where were you in relation?
I was just in the parking aisle just north and just a little bit west of the Mustang, where I had an unobstructed view looking southeasterly, if you will.
Are these photographs that actually you took that day during your surveillance operation?
I did not take this picture, but I believe another detective did.
That was working with you?
That's correct.
And during the surveillance operations by SIS, is it common that whichever detective has the best vantage point might take photographs or video or things of that nature?
Yeah, if you can work yourself in a position to take photographs and video, that'd be great. At least that would help the case, and we give that information to the detectives so they can sift through it.
And at some point, did you actually see the defendant with Robert Baker that day at this location?
I did.
Showing you People's 197 that has a number 32 in the lower left corner. Is this what you observed?
I did, but from the northwest of them, yes.
Yes. And so this was them coming out of the gym towards the Mustang?
That's correct.
Showing you People's 197, number 33. Is this another photograph taken of what you also observed that day?
Yes.
And the last one, 197, number 34. Can you describe for us what we see here?
To see Robert Baker at the passenger door, ready to sit down, and Monica Cimatelli is behind in the driver's seat, and they drove off together.
She was in the driver, he was in the front passenger?
Yes,
And approximately what time is this on June 6th?
I'd have to refresh my recollection. It was
Was it in the afternoon?
between 2 and 3.
Okay. And at some point in time before they had come out to the vehicle, was a vehicle tracker placed on this vehicle by Marcello Raffi, one of the other detectives working with you that day?
Yeah, that's correct.
And was this interaction between the two targets also caught on videotape that day?
I don't recall I can't recall the video. There's a videotape, but definitely photos.
Come on, dude. Ask again. Getting boring. Let me see what speed I have this on. Go to 1.5. And I'll zoom.
What do we hear in the background? Is that you guys talking on the radio? It says they came out with equipment.
It was probably me. I couldn't hear right there.
Oh,
Back below racket.
That's my voice.
Is that you broadcasting
Yes.
and also taking photographs?
Not,
Someone is?
someone's taking photograph. I believe this might be Detective Plaus, if I remember correctly. But I was definitely broadcasting the movement, walking to the vehicle, and then looking at the right front of the car.
appears to be looking at something on the vehicle, or at least around the vehicle talking.
Yes.
They're staying there for quite. Ow! Fuck myself. They're staying on that vehicle for quite some time. That's risky. I mean, what if they came out? What if somebody knows them that drives up and said, "Hey, these people were messing with your car"?
So is this typical of the type of surveillance that you did on the targets, where you would have a group of individuals, some would be narrating what they're observing, photographs or video may be taken, and you spend a lot of time waiting?
Yes, ma'am.
I'm waiting.
Yes, ma'am.
And that's still your voice broadcasting what you're observing?
Yes, ma'am.
How far is this location from Baker's apartment at 6817 Independence? Approximately.
I mean, he lived at Van Owen and Independence. This is Victory, I believe. One major south. Not too far.
A few miles.
A few miles, yeah.
You told us that this was somewhere between 2:30, 3 o'clock in the afternoon.
I believe so.
And did you follow them from this location to another location?
I stayed in the parking lot. I broadcast the movement. I don't recall exactly where they went from the LA Fitness.
Would it refresh your recollection to look at your notes?
It would.
Could you do so, please? They appear to be driving away now.
Yes.
Where did you follow them to?
So after they left the LA Fitness, they drove back to Independence, where Robert Baker lived.
And where did the defendant park her Mustang?
Refresh my look if it's in there. I wasn't on point, so I don't recall exactly where she parked it, but there was notes that were being taken.
And being broadcast to you?
Correct. '68 Independence parked in the underground garage of the apartment.
And a couple hours later, did the defendant come out of the apartment? Hour or two later?
Yeah, forgive me, this is 8 years ago, so I'm just trying to
I know.
refresh my recollection.
Just let us know when you've done that.
Yeah, that's a long time to testify back on. Very long time.
Well, after they left the gym, they went to Independence, then Monica left alone in the vehicle and then drove to the Ralph's.
Okay. That was a couple hours later, an hour and a half later?
Within the hour.
Approximately 4:15?
Yes.
I have nothing further.
Let's take our morning recess this time for 15 minutes. The evidence class. See you back here in 15 minutes.
They did a lot of surveillance on her. I'm really surprised how much work they put into that woman. What are y'all's thoughts on that? Okay, let me zoom.
A little longer than 15.
I believe it was.
Okay, I got to do another pupper break. I'll be right back.
Detective Frederick.
Good morning, ma'am.
Back in 2017, you were a member of this highly specialized special investigations section unit that was assigned to target Monica Cementilli and Robert Baker. Is that right?
Assigned to conduct surveillance of them, yes.
Okay. And that surveillance was conducted by your entire team at the time at SIS?
Whoever worked that day, yes.
Okay. And that was, you were briefed on your assignment and targeting Ms. Cementilli and Mr. Baker. Do you remember when you were first briefed?
I believe it was on March 9th.
Okay. And am I right that you, the surveillance team surveilled Ms. Cementilli and Mr. Baker, or at least tried to, from March through Ms. Cementilli's arrest in June of 2007? Is that right? 17? Is that correct?
But not every day. I believe I was only on 4 actual days of surveillance.
Okay. And of those 4 actual days of surveillance, am I correct? You only ever observed Ms. Cementilli with Mr. Baker on 2 of those days?
Definitely March 9th, I believe.
Okay.
And then definitely when they came out of the LA Fitness.
Okay. And that was June 5th?
6th, I believe.
June 6th?
Correct. And I did see Miss Cementilli driving the Mustang. I believe it was June 5th.
Okay. But that, am I right? That wasn't with Mr. Baker?
She was alone in the Mustang on June 5th. That's correct.
So on these 2 occasions, you actually observed them together. The observations you were discussing earlier on that video where there were shopping bags and clothes, you didn't see that in real time, am I right?
I did not see that, no.
Okay, so that was Detective Guzman who observed that?
I don't recall who was broadcasting, but someone had broadcast that they were looking at items on that Independence and Van Allen Street on the northeast corner.
Okay, but that wasn't you.
That is correct. It was not me.
And there was no, I was a little confused. There was no broadcast of video at that time. You weren't watching it live, correct?
That is correct.
Okay. And what you observed was in another parking lot on the 9th, and you saw Baker drive the truck into the parking lot. And at some point, Baker got out, Monica got out of the passenger side, and you saw some hugging and kissing and talking.
Yes.
And that was for, you think, less than 10 minutes. And then you followed their vehicle that evening on the 9th to the Goodnight Bar, and then later to a place called the Laugh Factory.
That's correct.
And then you left them there and finished your shift.
That's correct.
And on that surveillance that your team did, on that surveillance that your team did on March 9 and March 10, that's the only time you ever observed them, correct?
But then I believe June 6th at the LA Fitness.
Right, I'm talking about March 9, March 10.
That I observed them, yes.
Yeah, but you heard broadcasts as well?
Yes.
Of the surveillance, the other members of the team. How many members, how many detectives?
In 2017, I believe we had approximately a lieutenant, 4 D3s, and maybe 13 to 14 D2s, for roughly about 20 people assigned to SIS. But with days off and vacations, I couldn't tell you how many people worked. We do have a minimum of at least, I believe, 12 to 13 people that shall be in a surveillance. That helps with people getting out on foot. That helps with different looks of the vehicles. So it's not just me in surveillance, but the unit who was working that day.
It's a lot of manpower.
Yes.
12 to 13 a minimum.
Yes.
Okay. And am I correct that during your surveillance of Monica Cementilli and Robert Baker that day, you never observed Monica and Baker meeting with any other individual at any time, correct?
I did not observe that I can recall, no.
And am I correct?
I'd
At
like
no
to
time during
know.
your surveillance on March 9 or March 10, 2017, did you ever hear a broadcast of Monica Cementilli and Robert Baker ever meeting with any third person?
Not that I recall.
And am I correct that the only other time you surveilled and saw Monica Cementilli with Robert Baker was in that LA Fitness parking lot, correct?
Correct.
And at no time did you ever observe Monica Cementilli and Robert Baker ever meeting with any third person, correct?
That's correct.
And nor did you ever hear any broadcast from your specialized unit about Monica Cementilli and Robert Baker ever meeting with any third person?
Correct.
Nothing. Thank
Anything
you.
further by the people?
No, thank you.
Thank you, David Frederick. You're excused.
Thank you, Your Honor.
Thank you, next witness.
Thank you. People call Salvatore Pilera.
Can you please face me and raise your right hand? Just move over this way. Yeah. Do you solemnly state the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat and witness stand. And for the record, say and spell your first and last name, please.
Salvatore Pilera, Salvatore, Salvatore, Pilera, Pulera.
Thank you. Sir, did you fly in from Canada to testify in this matter?
Yes.
How are you currently employed?
I'm a sales manager for Kuhn Hair Cosmetics.
I wouldn't be. giving the name
And
of the company.
previous to that,
It's national
did you
TV.
work for Wella?
Yes.
Did you become a sales rep at some point in time for Wella?
Yes.
And prior to that, did you work as a hairdresser and a salon owner in Canada?
Yes.
Did you know Fabio Cementilli?
Yes.
How did you know Fabio?
I knew him through the show circuit, the hair show circuit. Him and his sister were very big hairstylists out there, award-winning hairstylists.
From Canada?
From Canada, yep. And I always followed Fabio and his sister, Morella. And then I started working with Wella and started working with Fabio. And I was introduced to him.
So you had heard of them and followed them before you actually knew him?
Yes.
And did you and Fabio become very close?
Yes.
And through your relationship with Fabio, did you meet the entire family?
Yes.
Did you know his wife?
Yes.
Do you see her here in court today?
Yes.
Can you identify her, please?
She's here in the blue blazer.
Before Fabio moved to the United States, did you attend a party or a gathering, basically like a goodbye party for him in Canada?
Yes.
And at that party,
That needed
did you
to be-
have any conversations with his wife, Monica?
Yes.
And did the defendant tell you why she had been convinced to move to the United States?
Yes.
What did she say about that?
She was happy with her life in Canada, but she was helping Fabio move on. She didn't want to go, but Ruben Carranza, which was Fabio's or the CEO of the company or general manager of the company, had a meeting with her and Fabio, and convinced her to come on board. They were going to pay for their move. They were going to pay for their travel. They were going to help Fabio out in every single way they could, between car loans and helping with rent and all those wonderful things.
Okay. Did she also mention anything about life insurance or benefits?
Yes. She was also concerned about benefits and life insurance because in Canada we have subsidized healthcare or healthcare in general. But Ruben had convinced her that there was going to be benefits, full healthcare taken care of. Everything was going to be taken care of for them.
And did she specifically mention to you that the life insurance and the benefits were something that convinced her to move to the United States?
Yes. Yes. She was convinced. The life insurance and the benefits were great. The salary was not that great, but the life insurance and the benefits were really good.
Six-figure
So she told you
digit
all that the
is
salary
not
wasn't
that
great.
great.
Those other benefits, like the life insurance,
Yes.
were great. Okay.
Yes.
And was Fabio someone that you looked to for guidance and training and teaching and things of that nature since he was older than you?
Sustained.
Did Fabio, at some point in time, once he moved to the United States, make you the regional education manager
Yes.
for Wella?
For within the Wella company, I was working with Cadis.
Okay. But it was under the
Yes.
auspices of Wella, yes?
Yes, definitely. Yes.
And did you, in that position, travel with Fabio several times?
Yes, many times.
Both inside the United States and outside?
Yes.
And did you even share a room on certain occasions?
Yes, many times. Yes.
Okay. And did he ever talk to you about anything that he collected?
Yeah. Well, he was collecting different things. Like he liked to gamble a little bit, very minor. And we got on the discussion of investing in gold, gold coins, different things like that. I think that was particular. We had that conversation in Orlando.
While you were traveling on one of these business trips?
Yes.
And did he tell you during your travel about the gold coin that he would collect?
Yeah, he would purchase it. I was interested in what he was saying because I've never purchased any gold coins. I don't know if it was a U.S. thing or whatever it was, but
What's overruled?
Go ahead.
Okay. So I was interested. So he let me know that he would purchase some gold coins. He even told me that you can get them at Costco.
And did he tell you that he would often use any
Gold
extra money
coins
that
at
he had to invest in
Costco?
gold coins?
Yeah.
What?
Whatever kind of extra money that he had kind of left over.
I never heard of that.
He would put aside, and Fabio was a guy who
Gold
was
in
like, he was a
Costco?
keep the money in the safe type of guy. And
Did he tell you that he used to keep his
but-
gold coins in the safe?
not particularly the gold coins in the safe, but he used to keep all his valuables in the safe. He didn't trust the bank.
Once Fabio moved to the United States, did you keep in contact with him on a regular basis?
Yeah, most of the time it was on a weekly basis. Sometimes when he was really busy, sometimes it would be on a bi-weekly or sometimes a monthly basis.
Did you come to the United States from Canada on several occasions to see him or for business?
Not to see him in particular, but for business, yes.
And that business meant that you would be seeing him, correct?
Always, yes.
And did you visit him at his home in Woodland Hills?
Yes.
And had you had dinner there on
Yeah.
occasion?
Yes.
And did you go house hunting with him as well?
Yeah, we went when he was first moving to the U.S. and he was transitioning. I was here at a 20th anniversary.
Maybe Stan is not responsive. It's overruled as irrelevant.
You went house hunting together?
Yeah, we went house hunting. We went to go look at different places before Monica and the family came down, and we went to go look at several different houses and different places. Yeah.
And once he purchased a house in Woodland Hills on Queen Victoria, when you would come to the house, was there a particular location where the two of you would sit and talk about business or meet?
Yeah, in the backyard.
On the covered patio area?
Yes.
And did you follow through the business Fabio's social media videos that he would post from that location on a regular basis?
Yes.
Training videos and things of that nature?
I don't know if they were training videos. They were awareness on what was happening within Wella, with industry, and of course his motivational quotes.
When was the last time that you saw Fabio prior to his murder?
June of 2016, I believe.
Okay. And were you in town that week for a training?
Yes.
And did you take a cab to the home on Queen Victoria to see Fabio?
Yes.
And did you come with another coworker?
No. I came in the cab alone. She came afterwards.
Okay. So she came separately from you to the location, to the residence.
Yes.
And when you got to the home, did Fabio let you in?
Yes.
Showing you what's been previously marked as People's 9. This one's page 8. Is this the residence that you came to in June of 2016?
Yes.
And when Fabio let you in, was Monica home at that time?
No, not at that time, no.
Did she come to the home shortly after you arrived?
Yes,
And did you and Fabio and the defendant have a conversation inside the home?
yes,
Where was that?
and the kitchen.
And did Fabio say anything to you that about that particular day?
Yeah, I didn't see him that day at the office, and he was at some show or some event, some OPI event in, I don't know where, but it was somewhere in Los Angeles.
Maybe Universal City?
Could be, yeah, yeah.
Okay. And what, if anything, did he tell you when you came into kitchen and you guys were talking?
I was making fun of him
Why were you making fun of him?
because he's Fabio was a big shot now, and just poking fun at him. And then when he asked me to come to the home, he said, "Let me know so I can open up the gates." And I'm like, "Oh, Big Shot has gates," and just joking around. And when I came in, I noticed there was a monitor on the kitchen counter,
Yes.
and there was all video cameras everywhere. And I'm like, "Oh, you have all these video cameras, you know?" And he had said to me, "That's not me. I didn't do that." And he said, "That's all Monica. That's all Mo.
Mo. That's
Yes.
how he referred to
That's all Mo." And I looked at her. I'm like, "Oh," and she says, "Yeah. Well, you can never be too safe. This is not Woodbridge."
Woodbridge is the area where you all lived in Canada.
Yes.
Did he tell you that he had come home to this?
Yes. He said, "I came home to this. This is all Mo."
Showing you People's 7, previously marked. It has a 29 in the lower left corner. Is this the monitor that you were
Why
talking
are you
about?
laughing?
Yes. Yes.
Same thing we see in Exhibit
I have
129, number 17. Yes? Same
Yes.
monitor on
Yes.
the counter?
Yes.
Your Honor, I have a Instagram post from June 28, 2016. May it be marked as People's 198.
Yes.
Showing you People's 198. Did you follow Fabio's Instagram?
Yes.
Okay. And Fob Style 67, was that his account?
Yes.
And the date here, June 28th, 2016. My wife and daughters don't know it yet, but Big Daddy is bringing home a few treats from OPI. Is that the kind of thing that Fabio would post on his Instagram account?
Overall.
Yes. He would always post things. He was very. He wanted his family always involved in everything he did. He felt that his success was only attributed to his family.
And so does that give you a timeline in terms of the date when you talked about Fabio being at an event in Universal City for OPI, the date that you came to the home being June 28th, 2016?
Yes.
So when he told you that he came home to this monitor, that Monica had had it installed while he was at this OPI event, her response was, "You can never be too safe. This isn't Woodbridge."
Correct.
Did you and the defendant often talk, and Fabio, about money and business and things of that nature when you would come to the home? Or when you would see him at events?
When I see him at events, we wouldn't talk about that when he came to the home, but at events, yes, we've had those conversations.
And did the defendant tell you prior to Fabio's murder that she was the one that handled the family's finances?
Yes.
Was that something that she had told you on many occasions?
Yes.
Why would you tell
Did
him?
she tell you why it was that she was the one who handled the finances for the family?
Because Fabio couldn't do anything on his own.
I'm sure Fabio loved to hear that. I would be happy for my husband to handle finances.
Now, as part
mean,
of
my
Bella,
strength.
did you travel with Fabio and Monica along with your wife on occasion?
On 2 occasions, we had the opportunity to travel to Hawaii, both Maui and Kona. I believe in 2010 it was Maui, in 2011 it was Kona, and we had the opportunity to travel together. Yes.
Could that have been 2011 to Maui in 2012?
Yeah, well, 2011 to 2012.
And did you and your wife have lunch and conversation with Fabio and the defendant on these trips?
Yes.
And was there a day where you and your wife spoke to Fabio and Monica about how they met?
Yes.
And did you all talk about how they had met at Fabio's salon in Canada?
Yeah, we talked about how they met in Fabio's salon, and
And was there discussion about P&G and some of the new benefits that were being offered on one of these trips?
yeah, we had a discussion about. I asked him, like, I mean, how are things going, and Monica had piped in. She goes, things are. I miss home, and but I'm here for Fabio. And I'm like, oh, things must be good. And she says, well, they help us with the rent. They help us with all these different things. It's definitely not the salary. It's the benefits. I mentioned stock options, but they
salary
were
a
great.
year.
The more time you had, they would get better. And all the different benefits that they were getting when it came to health benefits and bonuses. But she did complain about the salary. It's not the salary that's keeping us here at all. Definitely not the salary.
In
Why
addition
are
to the
you
stock
talking about your
options and the
salary
health
with another
benefits and the
employee to
bonuses,
begin
did
with?
she also say anything about life insurance?
Yes, she did mention the life insurance, and she had mentioned, yeah, it's not the salary that's keeping us here. He's worth more dead to me than alive. And Fabio's like, I'm worth more dead to me than alive. And then we all kind of laughed about it. It was a funny joke.
And did she specifically
You
talk
ain't
about
laughing
the
now,
life
are you?
insurance
Oh
being
no,
very good?
you didn't
Yes.
mean it.
Did the four of you also discuss the profit sharing plan?
Yes, we did discuss the profit sharing plan, and Monica said that was very good, and Fabio had said it too. And Fabio had asked me if I was taking advantage of it, and at the time I did not take advantage of it. And I think there was a timeline. Monica had mentioned the timeline. She said you have to take advantage of it before a certain timeline, and I never did end up taking advantage of it. So
Did Fabio say anything about the paperwork when you said there was a timeline? What he did with the paperwork for the stock options and the profit sharing and things of that nature, life insurance?
yeah, he did. He had meant I had asked him about. Oh no, so I had asked him about what is the timeline, and he's like, ask Monica because I don't know. She does all the paperwork.
Interesting. Ask
And did
Monica.
Bob
She
tell
does
you
it
that
all.
anything that was financial related, he put through her or he gave to her to handle?
If Fabio didn't handle anything on his own, he always had it. He always had his wife do everything because he was too busy to do things on his own. Maybe he was a little lazy, but his wife would do pretty much everything for him when.
Is that what not only Fabio told you, but the defendant told you herself on many occasions?
Yes.
Did she also tell you that she used to take care of the books or the finances in Canada when they opened Salon Fabio?
So I handle all the finance in my home when we were having that conversation, and Fabio had said, Monica's always done work. She's college professor. She works at Humber College, and she's smart. So I always left it to her.
And that was when she was teaching salon management type classes at Humber College?
Yes.
There's nothing wrong with one spouse
Did
taking
the
care of
defendant ever
finances,
tell
but
you
both of you need to know
the
what
amount
they
of
are.
life insurance?
Not a dollar amount, but she had mentioned I don't know how
You
serious it was,
do
but
need to know.
she saw it's millions. I don't know if that was serious or a joke. I don't know.
And that was something that the four of you would talk about together.
We talked about, yes.
Why did you talk about finances with your personal finances outside of the marriage?
Subsequent to
My
Fabio's
husband
death,
would be a
did you
millionaire.
attend
and I wouldn't talk about my
events
finances
in
with anybody.
Toronto for his
I might tell my
funeral,
mom, yeah,
memorial,
we're
things of that
comfortable,
nature?
we're good, but
Did you also attend an
mom,
event
but people like
at
you,
Morella's home with Marco
you
in
would know
Woodbridge,
damn
for
thing
the
about my
1 month
finances.
anniversary mass?
Yes.
And did you see the defendant at that event and back at Morella's home?
Yes.
And did you speak with her that night?
Yes.
And where were you when you had a conversation?
In the house and in the garage, smoking cigarettes.
And
make sure that's
were you
read.
talking to the defendant about what her future plans were?
Yes.
And what, if anything, did she say?
She had mentioned things like Fabio had a lot of ideas for new product designs and new products, and she got into that topic, and then she'd start to get really flustered, and she had said something kind of offensive, just something to the effect of, "I just want to fuck, I just want to fuck."
Was Morella there at that point in time?
I believe she was, yes.
And did she talk about the fact that she was moving on?
She said she wanted to move on, yes. I can't be like this all the time.
And this is the 1 month anniversary.
Yes.
Oh my gosh.
Did she say that? When she said that, did she seem like grief stricken, sad, more matter of fact? Can you describe her tone?
Matter of fact and upset.
Upset.
Yes.
By upset, what do you mean?
It just seemed like when she said it was more like anger.
Did she seem sad when she was talking about the fact that she needed to move on?
Not at all.
Did she tell you that she just, during this conversation, she just wanted to be free to do what she wanted to do?
Yes.
Did
I'm not
you
used to their line of
attend
questioning.
an event? I think it was June 11th,
They're like he's
2017.
testifying and he's
The Muir
he's
Awards
affirming.
in Toronto, where they were honoring Fabio.
Yes.
Did you see the defendant at that event?
Yes.
Did you do her hair for that event?
Yes.
And prior to the event, when you were set to do the defendant's hair, did she ask you to go somewhere with her?
Yes.
Where was that?
She had just, I don't know if she had just flown in. She had just got there at the event. I think it was the docks, Polson Pier in Toronto, where the event was. And Morella was supposed to do her hair, but Morella was coordinating the show, Morella was doing everything. So she was kind of flustered. Everybody was pulling Morella everywhere. So Morella had asked me, can you do Monica's hair? I said, do you want me to do your hair? And she says, yeah. She goes, but I need to have a drink first. I said, okay, we can go for a drink. So we went to go get a glass of white wine at the bar.
Was that the defendant's drink of choice?
Sustained on the first 2 rounds.
So the defendant had a glass of wine, you had a cocktail or something?
I believe I had a glass of wine as well.
Okay. And did the two of you talk?
Yes.
This was at the event at the docks or at Polson Pier where
Yes.
the bar area was set up?
The outdoor bar area.
Okay. And did she say anything to you at that time?
Yes.
And what was that? What did she want to talk to you about?
So I had a conversation with her about how she was doing and how everything's going. And she quickly told me that she was scared because the police wanted to talk to her.
Okay. And what did she say about that?
She said the police wanted to talk to her and she was scared. I think when she went back on Wednesday, or was it Tuesday or Wednesday, did she had to go back and she had an appointment with the police. She had said that they had found jewelry of Fabio's, but she doesn't know what jewelry they could have found because there was really no jewelry that was missing. And I said, okay. And she said that there's something that they found. I don't know. She goes, I'm just kind of scared. And I said, well, why are you scared? And she goes, you don't know everything that's happened and everybody's cut me off and nobody well talks to me anymore. They just let me be. Once Fabio's gone, nobody helps
You're
me.
rich.
I've been calling the police all the time for the life insurance money. I didn't get any money. It's not only for me, it's the girls. Are you going to pay my bills? Are you going to pay the gardener? All those things. So that was our conversation.
Okay. So she told you that Wella had cut her off.
Yes.
And did she specifically mention
Oh, when they're giving her
CEO
his
had cut her off?
salary.
Yeah, she said Sal Mosieri cut her off. Doesn't talk to her anymore. They don't help her. They haven't helped her with anything.
Did she tell you that Sal
It's
Macheri
good riddance
had,
against her.
along with Henry Meyer, had put into place a new policy and they were paying Fab's salary for 6 months to her?
Overall.
No.
Did she tell you that she had no money?
Yes, she did tell me that she had no money. I did offer to help in any way that she needed.
Did you offer to give her money?
Yes, I did offer to help money or anything that she needed. And she just kept on talking about how everybody cut her off.
And did she tell you at that point in time that people from Wella were constantly calling, coming to the house, bringing food, asking her if she needed anything? Did she ever mention that?
So she
Overruled.
said she hasn't spoken to anybody.
Did she tell you that Wella had actually paid to send Fabio's body back to Canada for burial?
No.
Did she tell you that people from Wella were getting her deals on hotel rooms in Las Vegas and Myrtle Beach?
No.
Did she tell you that she somehow had enough money to buy herself a new?
Here is a star witness, everybody, because let me tell you, here she is getting all of this stuff handed to her on a freaking silver platter. I bet he is sick to his stomach right now to think that she was lying to him and said they abandoned her. Let me be clear with you, boo-boo. Monica, listen. When I lost my husband, everything was cut off instantly. If you have a paycheck coming to your husband and that's all you're going to get, you're not going to get 6 months of pay. You're not going to get a company spending tens and $20,000 and $30,000 for memorial services in multiple cities and one in Canada. You're not going to get somebody who's going to pay to have your husband's body and remains shipped back to Canada and pay for the funeral. Bitch, please. This is pissing me off. For her to be lying like that.
New fully loaded Mustang?
Objection or amended?
Overruled.
No.
Did she tell you when she said she was calling law enforcement all the time regarding the life insurance that law enforcement didn't give a shit?
Yeah, those were basically her words. She had said that she calls them all the time that they don't give a shit. She said now they call me that they say they found something at Fabio's, but they don't understand. I need to take care of my daughters. I have no money.
And when she was talking about the police, did she tell you that
So you
she
go
was
on the
telling the
trip
police
to Las
or
Vegas
asking the
with the
police that they were going
boyfriend and
to
have
pay
no
for bills?
money?
Yes, she did say that. Yes.
Really?
Did she mention that Luigi, do you know who Luigi is?
Yes.
Have you met Luigi on many occasions?
Several occasions. Yes.
Did she mention to you that Luigi had already received his life insurance money?
She did mention that to me. Yes.
And what was her tone or demeanor when she told you that Luigi had received his portion of the life insurance?
She said Luigi had received his portion of the life insurance. I didn't seem that she was kind of upset about it, but she did say that that part of that chapter was closed, but her kids have not received anything.
And did she say, when you say not upset, did she seem like she was happy that Luigi had received his portion?
Sustained.
Did she seem, in terms of her tone, did she seem irritated, angry, happy?
Same objection.
Sustained.
Now, at some point, after you had this conversation with the defendant, did you do her hair?
Yes.
And where was that? Where did that take place at this event?
In the prep room, that we were doing hair.
And did Sal Macheri come into the prep room during this time?
Yes, he did.
And what happened?
Sal Macheri came in. He looked directly at me, and he said hello, of course, as he always does. And I was doing Monica's hair, and I kind of pulled her hair back, and she looks up, and he saw her, and he said hello to her, very professional. And she was just saying, she said hello back, but in a very low tone. And she was just muttering things under her breath. I remember her saying oh my God. And then she just kind of was muttering things that I couldn't understand.
And at some point later, were you on stage with Monica and Sal,
Yes.
Morella?
Morella put me on stage with a bunch of other people.
Okay. And did the defendant give a speech at the event? Did Monica give a speech at the event?
Yes, she did give a speech.
And then did she sing a song?
Yeah, she sang from a song or part of her speech was about Frank Sinatra. I did it my way. I don't remember her singing it, but I remember her saying something about or putting in her speech about Frank Sinatra.
Was that because you knew that Frank Sinatra was somebody that Fabio admired?
Objection, speculation, foundation, broadcast.
Sustained.
Was there a particular singer that Fabio loved that you knew?
Yes, Fabio loved Elvis Presley. He was crazy about him. I remember I had gone over to Salon Shampoo and was in the back, and then at American Idol they did like a hologram of Elvis Presley, and Fabio was like enamored. He had his laptop out and he was showing everybody and look at Elvis Presley and look how amazing this is, and he's the he was the guy he always loved. And I don't ever I know everybody knew that he loved Elvis Presley. I don't ever remember him mentioning.
Sustained.
Oh, I did it. Monday was an Elvis
Did you ever hear
Presley
him talk about
song, was
Elvis?
it
Have you
not?
talked about Elvis?
No.
Now, did you subsequently learn
never
that Monica
seen
had
that
Fabio's body cremated?
Yes.
Did you know Fabio to be somebody who was an Italian Catholic?
Yes.
Would that have been something that would be in line
Hey
with
guys,
what
I'm
you
gonna
knew about
go to
Fabio?
the restroom break. Now it's my turn in a minute.
Sustained. And it is.
Did Fabio talk to you about communion of your son and things of that nature?
Sustained.
You knew Fabio's family as well, correct?
Yes.
Including his mother before her death?
Yes, I met her. I met her.
Good morning, Mr. Guerra, right?
Yes.
Your testimony today started, you talked about the move from Canada to the United States, Fabio's family moving from Canada to the United States. Is that right?
Correct.
And that was back in 2010?
Somewhere around 2009, 2010. Yes.
Okay, so approximately 7 to 8 years prior to Fabio's passing. Is that right?
Yes.
And you testified about how there was discussion amongst you, Fabio, Monica, and your wife back in 2009, 2010 about the insurance and the benefits and everything Wella was going to do for the Cementilli family to move them to the United States.
No.
Please help me understand what I missed there. That it was-
So we had that discussion in 2011 in Hawaii. I had a discussion with Fabio, Monica, even Morella was around at his going away party in Toronto.
Okay, and that was 7 or 8 years prior to his death in 2017, correct?
Yeah.
That was also prior to Cody purchasing Wella in the fall of 2016.
Yes.
And you're aware that when Cody purchased Wella, all of the benefits, including life insurance and stock options, all of that changed, right?
Yes.
And at the time, you made a comment in your testimony that Monica had made some comment about the salaries not keeping us here, and there was communication about stock options. Do you remember that?
Yes.
And you are aware, as you said here, are you aware that Fabio was not granted any stock options until several years after his move from Canada?
Sustained.
And then you also testified about this trip in Maui where you guys had the lunch and there was the funny comment that you guys all laughed at. You remember that?
Yes.
And that was in 2012 or 2011?
2011.
Again, 6 years prior to Fabio's passing, correct?
Yes.
And you also testified that in speaking with Monica, she didn't mention a specific dollar amount, but you testified she claimed something about it being in the millions, right?
Yes.
And that was again a conversation that happened 6 years prior to Fabio's passing.
Yes.
How many times were you interviewed in this case?
By whom?
By law enforcement or the prosecutor?
Prosecutor, I believe it was once, twice actually, and never by law enforcement.
When were the 2 times with the prosecutor?
Back in just before COVID. I can't remember the exact dates, but it actually was during COVID and that whole time. Maybe it was 2020.
Several years after Fabio's passing, as well as Monica's arrest, right?
Yeah.
And during those several years, am I correct that you spoke to a number of people about this particular case?
No.
You didn't speak to anybody between June 2017 and the time you were interviewed? Anybody from Wella about the case? And
About the case, about Fabio's passing?
Did you speak to anybody at Wella between June 2017 and the date you were interviewed about a case being filed against Monica Simontilli?
Well, I know
Who did you talk to about it?
my wife
You didn't talk to anybody else.
about the case being filed. No.
Have you ever talked to Morella? Do you know Morella Simontilli?
Yes.
And you never spoke with Morella Simontilli between June 2017 and the first time you were interviewed by the prosecutor about the case and the alleged evidence against Monica Simontilli?
Not about the case. No.
What did you talk about?
She gave me some great baking ideas.
Okay, so nothing about. Okay, asked and answered. Let's move on. When was the second time you were interviewed with the prosecutor?
I'm trying to remember. I would say in early January
Of this year?
of this year. Yes.
How long was that interview?
I would say about 20 minutes.
Did you talk about anything new with the prosecutor in your interview this year, different from what you provided to her in 2021?
No.
Okay, you testified about this Orlando trip with Fabio and some discussion about coins. You remember that?
Yes.
When was that trip to Orlando?
I'm kind of thinking it was the Orlando Beauty Show. That's June. It was probably about 2015.
Okay. When you were first interviewed by the prosecutor, you didn't tell the prosecutor anything about this Orlando trip and gold coins and safes and Fabio can't trust the bank, did you?
It is.
When you interviewed with the prosecutor in January of this year, am I correct that it's the first time that you told her about this conversation with Fabio that he doesn't trust the banks?
No.
Okay. Is it your testimony that you told the prosecutor when you were first interviewed back in 2021 about this comment from Fabio?
I did tell her about this, yes.
Okay.
Whether she wrote it in her notes or not, I have no idea, but I did tell her.
At the June 2017 event to honor Fabio, Monica also told you during that time period that you were doing her hair, she had also expressed to you
I'm
her
sorry, I've been
frustration
sitting here.
specifically with
I
the
can turn the
Los Angeles
camera on.
Department, didn't she?
Yes, she did.
And you also testified that you understood
Yeah,
Fabio's
I
salary
did.
was continuing for 6 months, right?
I did not testify that. I had no idea salary was continuing.
Understood. You also testified that you had offered to give Monica money during this conversation, right?
Yes.
And at no time did Monica ever take a dime from you.
No.
Because she was lying.
The prosecutor asked
Just
you on
not a
her
bit.
direct about whether Monica had told you she was getting deals in Las Vegas. You remember that?
Yes.
Okay. And Monica, well, let me ask you this. Between January 23rd, 2017 and June 14, 2017, how many times did you see Monica?
I would say I saw her at the house. I saw her at the Wella events, maybe 3 times, 2 or 3
Okay.
times. Yeah.
You only saw her 3 times over a 6-month period, right?
Yes.
And you didn't.
Oh wait, I did see her in Toronto, at her sister's, supposed to be her sister's wedding.
And you also didn't communicate with Monica by text message at all between January 23rd, 2017.
Yeah,
June
and the
14th,
judge is
2017,
saying
right?
the same.
I did
Okay.
communicate with her.
How many text message communications
It
do
was
you
through
have?
Instagram messaging.
Okay, so Instagram messaging, but no text messaging, right?
No, text messaging, Instagram messaging.
Prior to Fabio's passing, how often did you talk to Monica?
Before he passed away, I haven't talked to her much at all.
Okay. In the year prior to Fabio's passing, how many times did you see Monica?
How many times have I seen Monica?
In the year prior to Fabio's passing?
I can't remember.
Okay. In the year prior to Fabio's passing, Monica didn't tell you when she was going on any other trips, right?
In the year prior to him passing away, did she tell me that she was going on any trips? I'm just trying to understand the question.
Yes, I'll clarify for you.
Yeah.
The prosecutor asked you on her direct questioning whether Monica told you that she was getting special deals, discounted hotel rooms in Las Vegas. You remember that?
Yes.
And prior to Fabio's death, Monica didn't communicate to you whether she was getting a great deal or a horrible deal on hotel rates anywhere in the world, right?
In other words, she didn't strike up
No, she didn't
a,
tell me that she
a
was getting any hotel deals.
more of a friendship until
She
after
did mention that
that.
she was going on a trip to Myrtle Beach to walk a golf course. Fabio was going to go for his 50th birthday.
Okay. But you were also living in Canada between Right. So you didn't know where Monica was going to lunch on the weekends either.
No.
You testified about this Elvis Presley American Idol with Fabio. When was that conversation?
2009.
Okay, so 8 years
You're-
prior to Fabio's
you're right,
passing, is that
Stone.
right?
It's all about
I
the
have
money.
nothing further, Your Honor.
Give me the money. Show me the money. Where's the
Why did the
money?
defendant tell you that she was going to Myrtle
I
Beach
just
to
dumped
walk
a
the
bunch
golf
of
course
beans.
for Fabio's birthday?
At Morella's house at the 1 month anniversary.
Did the defendant tell you she was going with her lover?
No,
She mentioned she had one?
no.
Nothing further.
Anything further? Thank you, sir. You're excused. You may call the next witness.
Who called Melanie Garibay?
I'm with the judge on this. We're going to be on this case to not this Christmas, but the following Christmas. I'm going to have all my regalia done, all the beadwork done. I have to make a beaded handbag for an old woman. He wants it for something special, and I need to get it done because I don't want her dying without it. Yeah, she's that old. So as soon as I get these beaded, I got to start working on that.
Do solemnly state the testimony may give the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth. So help you God. I do. Thank you. Please have a seat with the stand.
Ooh, pretty hair.
Spell your first and last name, please.
Melanie Garibay, Melanie Garibay.
Pretty hair. I know we're all about the hair. This is a hair company. They should have good hair. All of them. Well, except Monica, because she can't do that anymore. Although I think my hair's pretty cool.
Good afternoon, Ms. Garibay. Can you tell us how it is that you're employed?
Yes, currently I own my own company.
I work for myself.
Prior to that time, did you work for Wella?
Yes,
For how many years?
approximately 18 years.
Why are you not with them now?
And what was your position at Wella when you left?
I was the national show director.
What does that mean?
I was responsible for our North American show team and producing our shows and events across US and Canada, particularly the bigger events such as the North American Trend Vision Awards.
Let me. Thank you. In terms of being the national show director, does that mean that you were the one responsible for producing the shows?
That's correct.
What does that entail?
That entails coming up with creative concepts with people on my team, and then being the main liaison for the hotels or the event spaces, and then on site really producing and directing the large scale events.
When you say large scale, and are you referring to, like you said, the Trend Vision type shows?
Correct. I was in charge of our show team, and we did events large and small across US and Canada, as I mentioned. So my team was responsible for some of the more regional events, and I was responsible for the larger events, such as the North American Trend Vision Awards.
Events where you might have 1,000 or 2,000 people?
Correct.
And did you know somebody by the name of Fabio Cementilli when you worked for Wella?
Yes.
Were you on his lead team?
I was not on the lead team. I reported into Fabio as the national show director.
Okay. And so did you often travel with him to these large shows?
Yes, I did.
Did you and Fabio have a close relationship?
Yes, it was close. I met Fabio as a platform artist for my large shows. Then we were colleagues, and then he eventually became my boss.
And through that relationship, did you also meet his family, including his wife?
I did.
Do you see her here in court today?
Yes.
Can you identify her?
Yes, she's right there wearing a blue blazer and a light blue shirt.
With horrible head jail hair.
As part of your relationship, did you also, and your work with Fabio, did you also travel with them on trendsetter trips, bonus trips to Hawaii and things like that?
Yes, I did.
Subsequent to Fabio's death, did you go to the Cementilli home to offer your support along with other individuals from Wella on a regular basis?
I wouldn't say it was a regular basis.
Did you reach out to her on a regular basis?
After the murder?
Yeah.
I did check in via text here and again. I really didn't hear back much, but yes, I did.
All right. So you reached out and you also
I
went
tell
to the
you,
home
when
after the murder?
a lot of women.
Yes, correct. I believe I went 2 days after the murder
Would
with some
love
colleagues
to have
from Wella.
had this.
Did you also
report.
attend the backyard gathering on January 29th?
I did.
At some point later, did the defendant reach out to you and ask for your assistance?
Yes.
Oh
About
my
maybe
God! How many people did she do this
6 months
to?
after the murder?
I don't recall.
I'm sorry, 6 weeks.
6 weeks. Yeah, I think it was probably around March.
Your Honor, I have a Celebrate report with text messages between this witness and the defendant. It's 20 pages in total. May it be marked, please, as People's 199.
Yes.
My audio is funky, or her audio.
Showing you the first page of People's 199. Do you recognize the first instant message conversation as coming from you to the defendant on January 24th, 2017 at about 6 in the morning?
Yes, that's my message there.
Let me make sure I'm right on the time.
It says 7, I believe.
6:06 in the morning, it looks like, on the 24th?
Or 7:06 and 6 tenths of a second.
Yes,
Okay.
here it is, okay. And I want to direct your attention to
Testing. Is that better? I did some changing of the settings. Is that any better?
Is this again another text message that you sent to the defendant on January 25th?
Yes,
Talking about how you're bringing wine?
correct.
On the third page, another set of messages from you to the defendant just saying hello, thinking of you, sending prayers, things of that nature from, looks like January 26th, followed by maybe February 3rd.
Correct.
And the response, TY for thank you, is that the typical response that you received back?
Yes,
And then again, further down, February 15th, reaching out once again.
correct.
I now want to move to March 8th, bottom of the fourth page, just checking in, let me know when you feel up for a visit. Is this the type of text message that you sent?
Yes.
On the sixth page, on March 17th, do you recall receiving this message from the defendant saying, "Hi Mal, when you have a chance, could you give me a call?"
Yes, yes, I do.
And did you in fact give her a call as she requested?
I did. I specifically remember this because we were having a meeting, and just because I really hadn't heard, back in detail like this in a while, I thought maybe it was something urgent or important. So I did call her. Yes.
And what, if anything, did she want from you?
She said she didn't know if Fabio had let me know that she had a girls' trip planned, and she was wondering if I could help get her rooms at the Aria, since I had contacts there from previous shows I had done at Aria.
Okay. So she told you that she didn't know if Fabio had let you know about this?
Correct.
So in other words, indicating to you that Fabio knew she was going to be going on this girls' trip and to check in with you to get your help on securing a room?
Correct.
First of all,
During this
whoa, whoa,
time
whoa,
when
whoa,
she
whoa,
called
whoa,
you, or you called her, it was
whoa. No, no, honey boo. You cannot use corporate discounts and corporate connections for a private trip. This woman is acting like she's a jet setter. No. Okay, my spiritual mama used to be the one at these big resorts that handled setting up these big conferences for the hotels, and she would have a night fit if anybody from a corporation or business like this called in and said, "Well, we've got one of our people coming in for girls' weekend, and we wanted to know if we can get our special rate for them." No. That's the corporate rate is because you've got thousands of people coming. It's a corporate discount, meaning you book floors of rooms. You can't just sit there and take a corporate discount and apply it to 1 or 2 rooms. Unless you have a contract for that and that's because you're coming every weekend. But it has to be pertained to business and corporate. You are going to partay. So why is this company even entertaining helping this woman do this? I don't understand it. If I was this woman, I would tell her, "No, I'm sorry. This is only for corporate use, and you, honey boo, are not corporate. You, honey boo, is not corporate." I know. I'm getting on a soapbox.
response to her text message. Did she tell you that she had been very busy?
I can answer that.
Yes.
Okay. Yeah, she's, obviously busy with just a lot of things going on. So, understandable, I would think.
So given that she said Fabio knew about this, did you assist her in securing rooms?
I did.
And what did
If
you,
I was a
what were you able
hotel
to secure for her?
and I found out that
I
you
think
did
this
that
time I was able to
and it wasn't
secure
corporate, we wouldn't
some
have a contract.
suites at Vidara. I believe, if I recall correctly, there was something going on in Vegas for the dates that she was looking for. So my contacts couldn't get her a suite at Aria, but they were able to get her, at Vidara.
Okay. And for this
A
particular
suite, y'all.
trip, did she tell you that this was a
Pay
trip
for your
that
own damn suite.
was to take place between March 23rd and March 26th of 2017?
I believe those were the dates that she had me check on.
Okay. And were you able to secure her, when you say suites, they were the Sky Suites, correct?
Sky Suites would be at Aria, and then I don't know what they are at Vidara, but I believe it was a suite.
Council, let me interrupt. Let's take our lunch recess now until 1:30. The items supplies, not discuss this case either among yourselves or with anyone else with more expressing opinion to the cause. It's fine, submit it too. Have a good lunch.
Y'all, this is so unethical for her to have done that. And the fact that they are, and that woman assisted her in that. If I was with the company, if that was my company and somebody did that, I would be dismissing them. You do not use corporate contacts for that kind of personal use. You do not. Now, say you're the CEO, vice president, or you're way up in the organization and you're getting married, and they know it, and someone in the corporation wants to gift you a suite, but that's on their own dime. You cannot do this. it really angers me when people take advantage of corporations and things like this. It really does, because for me, it's like stealing. It's like stealing. I mean, I understand you want to go have a good time. I understand that the corporation and the people have a very good connection there. Okay, that's fine. But that's business. Part of that's a tax exemption. I don't know all the ins and outs. But am I right about that? Does that sound about right to you guys? I think it's unethical, honestly.
Did you receive this text from the defendant? Have you heard back yet? If not, no worries. How about you guys swing by tonight?
Yes.
Okay. And then, did
I
you
struggle with
respond? This is on March 20th at approximately 12:18 in the afternoon. And then you
fact that we
responded a
have
few
the golf
moments later saying, hi, thanks
court
for
is
reminding
getting
me. I just sent them another email.
Yes.
It wasn't, hey, we know you. No, it was.
And then what follows is a couple text messages between the two of you later that day, trying to make plans, correct?
Correct.
And the defendant says maybe next week, but she's leaving early Thursday morning. Correct?
Correct.
Looking at the next page, page 9. Later that day, at about 2:09 in the afternoon, did you send this text message to Monica?
Yes.
That they're going to try to get you at the Aria Sky Suites?
Yes, and then I was gonna try to get her confirmation number.
Okay. When you say they, were you referring to your points of contact at the hotel?
Yes, Mindy and Teresa.
Okay. And then subsequent to that, the defendant sent you a text message that included a photograph.
Yeah, this looks like her credit card.
Looking at page 10 of Exhibit 199. About 8:45 at night, did you send this text to Monica saying, hi, Monica, so we got you in a suite at the Badara. Mindy will send a confirmation number tomorrow?
Yeah, and then let her know she didn't need a credit card until she checked in.
And then in response, the defendant sent you back a text saying, great, thank you. Do you know the nightly rate?
Yes.
Looking at page 11, the nightly rate of $99. Is that the typical rate one would get at the Badara Sky Suites?
No.
This is your rate given the business that you do there, correct?
Right. Right.
Through
Correct.
through Wella.
Correct.
Or was doing there at the time.
Was that well? Yes.
And then did you send a message to Monica with respect to what Mindy at the Aria said with response to the reservation you were setting up for her?
Correct. Yeah, that's what Mindy sent to me, and that's what I forwarded to Monica.
And then you said, you are welcome, have fun, see you next week.
Yes.
And then you got from Mindy, Monica Sementili's confirmation number for March 23rd arrival.
Correct.
And you sent that to Monica?
Yes.
Now, in April of 2017, did you once again receive a text from the defendant?
Yes.
Showing you page 14 of Exhibit 199. Looking at the date of April 15th of 2017 at 12:52 in the afternoon, the defendant sent you a text saying, just found this. We both went Naha that night, and with a picture. Do you know what that picture was?
Yeah, that's a picture of Monica and Fabio winning Naha. So that's a hairdressing competition.
And then later on that same date, after the picture of the defendant with Fabio at 1:22 in the afternoon, did you also receive a text from the defendant saying that she was going to be going back to Vegas between May 3rd, and the 5th, and asking you if it was possible to get, again, a 2-bedroom suite or 2 separate suites.
Yes,
And then did you respond saying that you would reach out the next day and let her know?
correct.
Following day, on April 18th of 2017, did you receive a text from Monica asking you if you had had any luck in booking her in a 2-bedroom suite in Vegas?
Yes,
And then did you respond that Teresa, one of your contacts in Las Vegas, is working on it?
yes,
On the following page of Exhibit 199, page 17, did you receive this message from Mindy saying that they have a suite at the Vidara, 600 night, comp one night, 199 the other?
yes, that was from Mindy.
And then did you forward that on to the defendant?
I believe so.
Okay. And looking at a message from her a few moments later, is this for two bedroom? What is total for 290 for 2 nights? 199? Question mark sold! Exclamation points.
Yes, because they were gonna comp that first night, so it would have just been the 199 for the 2.
And then down below, did you respond yes? 2-bedroom suite, 199 plus resort fees on April 21st of 2017 with respect to her request to see if you could get her a discounted suite in Vegas in May.
Yes,
And then on the following page of Exhibit 199, which would be page 18 at the top, did you receive this response from the defendant saying that she would take it?
yes,
And then did you send her a message after that, asking whether she was driving or flying, and if she was flying, you were going to send the flight number
correct, because they would have arranged a car pickup from the airport.
also
Yes,
for free, included?
included.
And looking at the defendant's response, did she indicate she was going to book a flight that night?
Yes,
The following day, actually a couple days later, on April 23rd of 2017, at approximately 6:13 at night, she sent you a message saying my arrival with a flight or a photograph of her flight, correct?
flight itinerary, yes.
Your Honor, I have that photograph, maybe marked as the people's next in order. Is that 200?
It is.
Thank you. Showing you people's 200. Is this the photograph that she texted to you of her flight information?
I believe so.
Pretty grainy. Can you see from that it looks to be flight information, LAX to Las Vegas?
I can't see from that image there, but from the one you just showed.
Yeah, looks the same, 200. For Wednesday, May 3rd of 2017, correct?
Correct.
And then you asked her which airline, and she told you on April 24th, 2017, American Air.
Correct.
So are you telling me, because I had to pull out for a minute. I was here, but I had to
Page 20 of your
mention
text,
elsewhere
you send
that
this message
this lady arranged her whole trip, like no.
approximately 11:50 in the morning. Hi, Monica. Hope everything's going well and that you had a fun time in Las Vegas.
Yes.
I'm kind of floored.
After the Wella Memorial, which took place on May 22nd of 2017, did you go to the Cementili home to meet with the defendant regarding a Trend Vision show that you were going to be putting on in July of 2017?
Yes, I did. I went with my colleague Carol.
Carol Protat?
Carol Pota, yes.
And what was the purpose in going to the home to meet with the defendant regarding this show after Fabio's death?
So all year after Fabio's death, we had been kind of doing tributes and memorials at all the shows that we were producing. This one, particularly the North American Trendvision Awards, we went over there to
That's
talk
on
about
their
our
end.
participation and how we wanted to honor Fabio at this event. So that's what that conversation and the visit was all about.
Okay, so you went over there to talk to her about her participation in the show you were producing?
Correct.
Okay. And when you got to the house, did the defendant tell you that she had just purchased a new vehicle?
She did. She was really excited. She was excited to show the car to Carol and I, and said, "You would have been so proud of me, so proud of me. I did an Academy Award winning performance so that I could get a good deal on the car."
Did she tell you that she was a great actress?
Great actress. I really remember the Academy Award winning performance.
Did she tell you that she bragged about using Fabio's death in order to get the good deal?
Out loud.
Yes, she said that she played, the grieving widow. So the advantage of getting a great deal on the car.
And then at that point, did she actually show you the vehicle?
She did. She took us out to the garage. And I remember specifically there was lights that shined down from when you opened the door. It had the, Mustang logo. And yeah, it was just, yeah, I remember that specifically.
And when she was talking to you about the great deal that she got on this new Mustang, did she tell you that she traded in Fabio's truck to get the car?
I don't recall. I believe so.
And at that point, did she tell you that she was going to be traveling in the next couple of days to Myrtle Beach?
She did. I remember her saying that, yeah, she was going to Myrtle Beach to walk the golf course because it was one of the things on Fabio's bucket list. And she didn't play golf, but she was going to, honor his memory by doing that.
And did you ask her about whether or not she was planning on moving back to Toronto?
I did. I think in different conversations we had, I asked because I know that obviously she was from there, the girls, and yeah, she just said she didn't know. Things were taking longer than she had planned or expected, or she just kind of seemed frustrated at the process of trying to figure out, what had happened to Fabio.
I have nothing further. Thank you, Your Honor.
Good afternoon, Ms. Garibay. I don't want to take up too much of your time. You testified about helping Monica get some really cheap hotel rooms in Las Vegas, right?
Correct.
The rates, the prosecutor went over with you. One of them was $99 for one night.
Correct.
And I think you had already testified these rates were extremely cheap and different from what the rates would normally be.
Correct.
And on the People's Exhibit 199, the first time that Monica had reached out to you, you were happy to help her getting a discounted hotel room, right?
Yes.
And you had texted Monica, hope you have a good time while you're away, right?
Yes.
You did that for both of the trips, that hope she had a good time and have fun.
Yes.
How many times did you see Monica between January 23rd and June of 2017?
Maybe 3 or 4 times. I mean, including the night of the wake, or just like on personal visits to the.
Including the night of the wake.
I know we went over a couple of days afterwards, as I mentioned. We went over with some colleagues from work right after it happened. I was there at the wake, and then I know we went over another time just on a visit. My husband and I had been out riding, and we brought wine over from Santa Barbara. I believe Carol might have been over there, maybe Mark. It was just a friendly visit. And then the next time I can remember was when Carol and I went over in May to discuss her participation for NATVA.
Okay, so you saw Monica a total of 4 times between January 23rd and June 14th, the day that of the arrest. Is that right?
From what I can recall, yes, I believe that's correct.
Okay, and on only one of those occasions, did Monica, on the last occasion, I believe you testified that Monica expressed frustration with the status of the LAPD investigation. Is that right?
I'm gonna say that wasn't the last one. I'm gonna say maybe the third time. That's when she was kind of starting to seem frustrated. The last time we went over, it seemed like she had a very different demeanor. I mean, she was super excited about the car, and just kind of, you know, moving on, I guess, doing these things for Fabio, but I didn't get any sense of frustration from her in that last visit.
With respect to the Mustang, what that day that you went over to Monica's house and she was telling you about the Mustang, she was really bragging about she had negotiated a really good deal on this car, right?
Hey, out and about, Diane. Hello.
Who doesn't love a good deal on a car, right?
Thank
You previously testified that, am I correct that you previously testified you reached out to Monica between January 23rd and June 14th, and Monica was busy?
I mean, I reached out, you know, after January 23rd. Understanding a grieving widow, she's got a lot of things going on. So I didn't want to be intrusive, but I just wanted her to know, you know, hey, we're thinking about you. But yeah, I don't really think it was all the way up until June. I think after the hotel rooms, you know, that's kind of really the conversation we had.
Well, between January and June, in the text message communication with Monica, she actually invited you over a number of times.
No, I think there was maybe once or twice. She didn't invite over multiple times. I think there just a couple times. I mean, you look back at the text, but we weren't that super close. I mean, obviously we knew them because of Fabio, but I'm sure there were other people in her circle of friends who were way closer that, you know, she would have loved to have at her house besides me.
But Monica did invite you over a couple of times, is that right?
I think once or twice.
And on both of those occasions, you were actually the one who was busy and couldn't make it on the night she invited you over, right?
I'm not sure.
You may have a moment, Your Honor.
What?
Happy to help her booking rooms in Las Vegas.
Communication string between Ms. Simontilli and Melanie Garibay, if it can be marked as the defense's next.
That'd be 619. Is this a duplicate of the People's?
I have not seen it in this 20-page.
All right.
I'm not seeing it in People's Exhibit 199. Charging into this green bubble, March 20th, 2017 at 12:19. Is that a text message from Monica to yourself? That's 702 phone number.
That's correct.
And she asks, have you heard back yet? If not, no worries. How about you guys swing by tonight?
Yes.
And in response,
So that's the response that's in the other one you just showed me.
and at the end of it, it's can't do tonight. What about Wednesday?
Correct. That was the one that was just in the one you showed me.
And that was one of the occasions in which Monica invited you over, but you were unavailable.
Yes.
Nothing further, Your Honor.
Anything further by other people?
When you were happy to help her booking rooms in Las Vegas, you didn't know, she didn't tell you she was going with her lover, correct?
Objection, argumentative, cumulative, relevant.
To stand on the second round.
With respect to the message the defense just showed you, it's the same one I showed you, correct?
Yeah.
Looking at exhibit 199 at the bottom, top of page 8.
Correct. My response is the same. Monica's text there just looks like there might have been something missing on the bottom. I don't know, but it looks like it's the same.
Anything further? Thank you, Mr. Garvey. You're excused.
Thank you.
May I call your next witness?
Thank you. People call Sheila Salahian.
Yeah, that kind of ticks me off when we get to the point where they're talking about this woman arranging using corporate connections, vacations, and flights and hotel rooms and all of that. It's like, no, I don't go for that, Miha. She was trying to be a jet setter.
In 2017.
Correct.
Which gym was that?
LA Fitness in Woodland Hills.
We're gonna ask you to speak a little closer to the microphone, so go, thank you.
Okay.
Thanks.
When you, back in 2016, and let's start with 2016. Back in 2016, did you already know Robert Baker from the gym?
Yes, I did. I think I met him in summer of 2014.
Okay. So you had already known him for a couple years.
Correct.
And did you meet him at the gym?
Yes, I did.
And did you play in a racquetball league at LA Fitness?
Yes, I did.
And was Baker the racquetball league coordinator?
Yes, he was.
And when you played, did you play a certain night of the week in that league?
I think it was Thursday night when I played. Yes.
And when you played in that league, did you also play with the defendant?
Yes, I did.
Show me what's been marked. Previously as People 71, there is a 3 in the lower left-hand corner. Do you recognize yourself and your husband in the left side to the left of this picture? You're in a yellow, it's like a yellow tank top, drinking some water.
Yes, I do.
Is this your husband, Ricardo, next to you?
Yes, that's right.
And do you recognize the 3 individuals in the photograph next to you?
I do.
Okay, who are those individuals?
Elise, Faye, and Monica.
Were they also, Elise and Faye, women that played in the racquetball league on Thursday nights with you?
Yes, they were part of the racquetball league.
In early 2016, did you and Ricardo begin going out with the defendant and Robert Baker as a couple?
Yes, we did.
And at the time, did you know that the defendant was married?
Yes, Rob had mentioned that Monica was married.
When Rob mentioned to you that Monica was married, had he mentioned that to you in front of Monica?
He mentioned that, I believe, before we met Monica, and also mention of that when we were out to dinner. Yes, I believe so.
And when you and Ricardo would go out with the defendant and Baker, was it clear to you that they were a couple?
Absolutely.
What did you observe when you say absolutely that indicated that to you?
They were very affectionate towards each other, holding hands, and we basically going out together to dinner. So that's definitely showed that they were a couple.
Did the defendant ever mention in all of the occasions when you guys would go out as couples, her husband?
I don't remember her mentioning. I don't think she did.
Did you ever meet her husband, Fabio?
I did not.
After his murder, did she ever mention him then?
Never.
Did she ever bring up during all of the times that the two couples, you and Ricardo and she and Baker, would get together, did she ever mention her daughters?
I don't think she did. No.
When you said affectionate, would they touch each other?
Touching, kissing, very close to each other. Yeah, holding hands.
What are some of the places that you double dated that you would go out to?
I'll hear it.
We went to a few different restaurants. It was a sushi bar that we used to hang out at because they closed late. So after the gym, we would go there. It was called Chocho-san. I was in Tarzana. We also went to, I believe, Delmonico's.
steak and lobster place?
Yes. And Cravings, the steakhouse.
So did you go out for sushi several times to Chichi-san?
We did.
Craving several times?
I don't remember several times, but I think at least one time.
And did the defendant and Robert Baker come to your dad's home for a barbecue and party March 14th of 2017 after the murder of her husband?
Yes, they did.
Now I want to ask you about Monday, January 23rd of 2017, the night that Monica's husband was murdered. Did you go to the LA Fitness gym in Canoga Park that night?
Yes.
Did you take like yoga classes on Monday nights?
Yes, I did take yoga class.
And was that also night?
Yes. That was when I believe the upper level racquetball players were playing.
Like your husband, Ricardo?
Yes, Ricardo was playing then.
And
Yes, that's both part. Yes, in front of her.
at any point, did the defendant dispute that fact or say no?
She did not.
These conversations where they would
remember
you plans before Fabio was murdered.
Yes.
Okay, that was weird, y'all.
Had nothing further.
Let's take our after recess for 15 minutes.
Okay.
The evidence supply. Be back quickly.
So they got a 15-minute break. Okay. You guys, y'all go to. Nope, it's not there. Let me pull it up. Tanika has dropped a video that I did with her. Share. Copy link. I'll put it here. You guys can go watch it. It's about Miss Karen Reed. I hope I did a good job. I hope I did good for her. I really like Tanika. She's a blast. We have a great time. Had a great time. So anyway, y'all go watch, support her, like, subscribe if you want, although she's got 10,800 subscribers. So yay, go love on her a little bit. So I am looking for, we go to X. The young kid that got accused of that stabbed his twin, he could get anywhere from 5 to 99 to life. He was given 15. Oh, let's watch this.
The Commonwealth appears to be believing
Guy in
that
a
they
pink
got
shirt
the
came in the
information
door.
from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline.
Line number 2.
Defendant provided an outline of the question and answers for direct examination.
Line number 2.
Why? That's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll stop back up at 2.
Are you an outline?
That was pretty abrupt. I remember that. I thought that was way abrupt. I didn't understand why she was so abrupt on that. That was insanely abrupt. I'm looking at the date on this. Nope, that's not going to help us. I'm looking to see if there's anything new that has dropped in the Karen Reed. If you guys see anything new that drops, please go to Discord into member chat or private chat me and definitely hit me up. Let's see, what does he have to say? Oh, he'll be live. I'll be watching at 7:30. I love it. Lawyer, said, okay. At the beginning part of this, and I'm going to go ahead and show it. He's not going to get upset for me doing that, I hope. Okay. The invoice discussion is revealing. The defense argues everything that was said was true at the time it was said. Invoice came out of the blue. P.S. The invoice was not just cost, reimbursement, or travel, but trial prep. I grabbed that and I went, uh-oh. And the defense was shocked by the amount, but they did pay it July of 24. The legal analyst of this is that's important as the facts, but it is nice to get some actual facts on the record to make our jobs a whole lot easier. Amen to that, brother. Then he said, words matter. Words do matter. Judge Canoni would not really throw Jackson off the case, would she? I just can't imagine it happening. Talk about going viral. Some of her questions seems like that's where she's leaning, but can it be? And then he says, everybody take a deep breath. I love it. Everybody take a deep breath. It's okay. We're going to be okay. Everything's going to be fine. There may be some dancing going around on the prosecution side and the defense side when all this is said and done, but it's going to be okay. Everybody take a deep breath. I love it. She was hungry. I mean, she was out for wolves. She was a wolf on a prowl hunt. That's old. When was this filed? Oh, is this new? When did this drop? Oh, what's today? Okay, this dropped yesterday. Did we read this one? I'm Martin G. Weinberg, a member of the bar for this court and counsel for petitioner Karen Reed, hereby pursuant to Rule 83.5.3 of the local rule of the United States District Court of Massachusetts that Alan Jackson, an attorney of the state of California, be admitted to appear and practice in for this court for the purpose of representing Karen Reed as my co-counsel in the above captioned manner. I have advised Mr. Jackson to admit to practice and member in good standing in the state of California. Certificate of good standing can be provided if necessary. I have been advised that Mr. Jackson is not currently suspended or disbarred in any jurisdiction and that there is no disciplinary proceedings pending against Mr. Jackson in any jurisdiction. I have further been advised that Mr. Jackson has reviewed and agrees to comply with all the local rules of this court. Okay. So there you go. They had to do this the last time. This is not new. But it was done yesterday. Okay. Now this was also done late yesterday. I, Alan Jackson, affirm the following in the pains of penalty of perjury. I'm an attorney duly admitted to practice law in the state of California. I submit the affirmation in support of the motion seeking my admission to the bar of this court pro havoc, I can't say it now. Pro havoc, pro whatever. For the purpose of representing petitioner Karen Reed. Dyslexia sucks sometimes, y'all. I'm a member of the bar in good standing in every jurisdiction in which I have been admitted to practice. There's no disciplinary proceedings pending against me as a member of bar or of any jurisdiction. There's no disciplinary proceedings pending against me as a member of any bar or jurisdiction. I have not previously had a Provax admission any other admission to this court revoked for misconduct. I have read and agreed to comply to the local rules of the United States Court of the District of Massachusetts, blah, blah, blah. Yay! Somebody wants to know how many of the Boston's trash media outlets are going to do a retraction immediately. They again completely tainted the jury pool with their irresponsible false reportings that the federal investigation was over and no cop we be charged. They all lied. What? Oh, Adrian Carney says, I can't believe this idiot judge is allowing an entire day to be wasted on this. The ARCA expert didn't testify that John O'Keefe wasn't hit by a car because they being paid. They said that because they were following the science. Someone said, are you encouraged or discouraged by the decision of the feds not to continue following the investigation? Karen Reed, I didn't know that. I believe that. Steve Cooper, oh, it's an interview as she was walking into court. Oh, I loved it. The part where, shh, that's fine. Robert Alessi embarrasses Hank Brennan in front of the world. I love it. Oh, Ian Runkle. Yannetti blew open the doors on the first trial with a fire axe. Now we're seeing, I don't know how to say his name. Someone put it in here for me phonetically. Alessi wielding the scalpel. Alessi says that Judge Canoni's concerns last week and decision to postpone was a result of several serious inaccuracies by Brennan. They're chasing a ghost. Commonwealth repeatedly misrepresents the facts to generate headlines, only for the defense to follow up with rational explanation that fully debunks the narrative. No. It's the one that spoke today. It's Alessi. Alessi? I find it interesting too. Karen Reed updates. Someone stated the Commonwealth is upset over the emails, but not Jen McCabe's Google searches. Oh, somebody else said, Microdot said, Alan Jackson, thank you for keeping the hot seat warm for Hank Brennan. Brennan left out the word pause from an email he quoted, changing the meaning of the message and misrepresenting the evidence to the judge in court. Brennan's misredirection. Either Hank Brennan is genuinely confused about the timeline, the evidence that was in his possession and when, and lacks basic comprehension skills when reading the transcripts, or he's lying. Wow. Okay, Microdot's frozen in cement. The key takeaway from the Robert Alessi is what I'm going to call him arguments is that ARCA findings that John O'Keefe was not struck by Karen Reed's vehicle and that her vehicle never hit him were determined long before they ever communicated with the defense and never changed. That is so true. And I said it earlier. They did not change. Oh, I'm not going to talk. I'm not going to read this guy. He admits to being, and I'm not going there. So I agree. I'm shocked, but not shocked.
Present, all council present, jury and also present. Ms. Gillian, you are still under oath. Mr. Babbitt, you may inquire.
Good afternoon, Ms. Leahy.
Good afternoon.
I'm going to ask you a few questions. Just let me know if you don't understand anything I say or if you need me to clarify something. You testified earlier and were shown Exhibit 204 by the people, the text messages. Do you remember that?
Yes.
And just want to point out, there's a text message which you sent initially, correct, on February 6, 2017, giving your condolences to Monica.
Correct.
And then she responds saying, "Thank you so much. We're still in Toronto." You went over this with the prosecutor, correct, previously?
We did.
And then you also then send a message on 14/2017. Sorry. Do you see that message?
Yes. I do.
And what is that message?
That's a Valentine's Day message.
And you sent that to Monica first, correct?
Correct.
And then Monica responded on February 14th saying, "Thank you, happy Valentine's Day," correct?
Correct.
You testified earlier that Robert Baker stayed at your place from February 6th to February 8th. Is that correct?
That's correct.
And then you said after the fact that you guys essentially stopped talking for a little bit with Monica and Robert, correct?
Yes.
That message you sent on Valentine's Day was after Robert.
June, I know the court says his name, but with my hearing, most of those letters I can't hear.
Baker had left your place.
I'm reading.
True?
People don't realize sometimes I'm like this. I'm captioning.
Also,
over here.
you
I can't hear
testified
it.
that you went with Rob, your husband, and I believe Matt to Monica's house that one night.
Yes.
And what time did you arrive, if you remember?
I don't remember exactly, but I think it was dark.
It was dark, and when you arrived, there were already a lot of people there, correct?
Correct.
And they were all outside in the patio, and some were inside, correct?
Correct.
And were you the last one to leave that night?
No.
So you testified earlier that you saw Monica and Rob outside by themselves, but weren't there other people also outside at that time?
I remember them. I only remember them talking. I believe everybody else was inside.
So no one was outside, not the caterers, because there was food there, correct?
There's food inside, yes.
There wasn't food outside?
No,
There was no taco set up outside?
I don't remember that.
Weren't there a lot of people hanging out by Fabio's shrine throughout the night?
Yes.
But for that specific time, you don't remember anyone else being outside when Robert and Monica went outside?
Correct. I only remember them two talking. Yes.
Could there have been other people outside at
Could
that
have been,
time?
but they would have been very far from them. Would not be able to understand the conversation.
Well, you didn't understand that. You couldn't hear the conversation either, correct?
No, I couldn't.
Also, you remember testifying earlier that Monica brought up that she and Rob had a future together back in 2016, correct?
Yes.
That you had conversations with her and Robert together about their future together?
It wasn't very specific, but they were talking about mostly Rob talking about Monica leaving the husband and being together in the future.
You said mostly Rob. Wasn't it only Rob who said those kinds of things to you?
I'm remembering mostly him. Monica was more quiet when we went outside, when we went out to dinners. Most of the conversation was done by Robert, but she went along with it, and she did not say anything to the opposite.
Did you ask her?
No, I did not.
Do you remember testifying at a grand jury back in August of 2017?
Yes.
Is that a yes?
Yes.
Thank you. And when you testified at the grand jury, do you remember being or saying that Monica never talked about their relationships with me?
Their relationships, meaning her and Robert?
Yes.
Nothing detailed was spoken, but general stuff like we love each other, or we want to be together, or something like that.
Didn't you also testify at the grand jury that the only one who did speak about their relationships was Rob?
It was mostly Rob, yes.
Sid, as you sit here today, can you think of any specific example where Monica brought something up to you, or was it only Rob that you can remember today?
It was mostly Rob. That's what I remember. But she was there. I remember at least once that she said we were planning to be together in the future.
You remember that?
Yes.
Alessi?
So
That it?
was it true when you testified at the grand jury that only Rob was the one who talked about their relationship?
I meant talking about the details of the relationship.
Let's see.
So Monica
Thank
never
you.
brought up the details of their relationship to you?
That's perfect. Thank you so much.
What do you mean by details?
Their future together, details like that. That was Rob who steered that conversation with you, correct?
Mostly.
You and Rob had a longer history than you did with Monica, right?
Correct.
You were closer friends with Robert than you were with Monica?
Yes.
And was that the first message we saw, the first message you ever texted to Monica? Or
Which
were you
message?
the one on People's Exhibit 204? Or did you guys have conversations prior to this via text message?
I don't remember having a conversation with her before that. If we did, was maybe about the racquetball league or something like that, but no.
So you and Monica weren't close friends specifically. Whenever you guys would hang out, it was with the boys as well, correct?
True.
Nothing further, Your Honor.
Anything further by the people?
When you were asked at the grand jury about the details of the relationship, that was with respect to comments about their sex life.
Exactly, yes.
It's a different thing than talking about their future, correct?
Yes, Rob was talking about a lot of sexual explicit things with Monica.
Anything further, Mr. Batters?
Yes, Your Honor. Ms. Salahian, would it refresh your memory if I showed you a transcript of the grand jury about specific lines regarding Monica's statements about their relationship?
I'm not sure what you're referring to.
Your testimony at the grand jury, would it refresh your recollection as to what you said about the specific conversation that Monica had?
That could help.
Your Honor, may I approach?
It has been 6 years, I believe. It's been quite a bit of time. So Yeah, most people forget about my hearing, and it's okay until they see the big hearing aid. I mean, these are big, y'all. I've had bigger. They've gotten smaller over the years,
To
but
yourself lines 23
having those
to
behind your
28.
ears with
Let me know when
glasses all the time can cause some
Did
discomfort.
Monica? Oh,
read it to yourself.
oh, okay. Okay.
Does that refresh your recollection that it was only Rob that talked about Monica and Rob's relationship with you?
Yes, that does.
Thank you, Your Honor. Nothing further.
Anything further?
No, thank you.
Thank you, ma'am. You're excused. Mika, your next witness.
Thank you. People call Ron Ray.
You guys, it got to 81 degrees today. Don't worry, I'm only getting 3 or 4 at a time, and they're the mini ones. My lip gloss is sticky, so it sticks very well to it. I wanted to zoom, but we can't. So 7 states. Here's a little statement. There are 7 states that will not be getting a Buc-ee's. Vermont, Alaska. Well, no kidding on Alaska. Um, Idaho, Hawaii, Maine, North Dakota, New Jersey. They will not be getting a Buc-ee's, and they don't know what they're missing out on. How many of you guys love Buc-ee's? If do you even know what a Buc-ee's is? Some of you. I will tell you, they have the cleanest bathrooms any place I've ever been. Well, you know, gas station restaurant.
And do you solemnly state the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth? So, yeah.
I do.
Thank you. Please have a seat with the stand. And for the record, say and spell your first and last name, please.
My first name is Aniruddha, Aniruddha. I go by Ron, Ron. My last name is Ray.
Sir, did you and your wife travel to Los Angeles from the Nevada area?
Yes,
Do you know somebody named Robert Baker?
yes, I do.
And
Come on,
when
guys,
did
can
you
get
meet
the like
Rob
button?
Baker?
We only have 6
Probably
registered
January
drawing
of
out of 13.
2012.
And at that point in time, where did you meet him?
I love
We played racquetball together at
Mm.
Las Vegas Athletic
Stop
Club,
it, everyone. I passed.
where I used to train and
I'll
play
be right back.
racquetball.
And was Robert Baker living in Las Vegas at that point in time?
Yes,
And did the two of you become friendly and start
Yeah.
playing racquetball together?
yes. We probably spent anywhere from 4 to 6 hours every night playing racquetball. We lifted weights and also played basketball together.
During that period of time, did you meet Robert Baker's wife, who is living with in Las Vegas, then a woman by the name of Tracy?
Yes, I did.
The last time that you saw Robert Baker, do you recall when that was?
It was May of 2017, after Robert's birthday party we had in Marrakesh. And then we went to the strip club. I dropped them off, got them in.
Sustain.
We'll get into the details. So the last time you saw Robert Baker was in May of 2017 in Las Vegas.
Correct.
And did he come to Las Vegas with somebody?
Yes,
Who was that?
Monica. Well, I have her in my phone as Monica Baker, but Monica Sementelli, I guess.
Did you ever know the name Sementilli?
No.
Okay. You knew her by Monica Baker.
Yeah.
Do you see her here in court today?
Yes.
Can you point her out for us?
She's sitting right there in the blue jacket.
Did you first hear about her from Robert Baker through a set of Facebook messages that he sent you in November of 2016?
Yes.
Your Honor, I have a set of Facebook messages between this witness and Robert Baker. It is 14 pages in length. May it be marked as people's, is it 207? 206. Thank you. In November of 2016, did you communicate with Robert Baker through Facebook?
Yes, I did.
Showing you the first page of People's 206, is this a message that you sent to Robert Baker asking him if he was dating anybody or making any money with his league?
Yes, that was me.
And did he respond at the bottom? This is November 12th of 2016, that he's been with his girlfriend for about a year now.
Yes.
For a year.
Yes.
Did you also ask him if he was living with her?
Yes, I did.
Did you also ask him to send you a picture of her?
Yes, I did.
And is this one of the pictures that Robert Baker sent to you of his girlfriend?
Yes.
Is that a photograph of the defendant who you subsequently met,
Yes.
as you talked about in May?
Yes, that's her.
And did he respond to you on November 12th of 2016 that they weren't living together yet, but that it was coming soon?
Yes, he did. And then we talked about it later as well.
Is that yes?
Yes,
Did he also send you through Facebook Messenger this photograph of him with the defendant?
yes,
This is page 5 of People's 206. On page 6, did he also message to you again on November 12th of 2016 that she's grounded, smart, and loves my crazy ass?
yes,
On page 7 of People's 206, did he also tell you that he and the defendant, or Monica Baker as you know her, are planning a vacay to Vegas soon?
yes, he did.
And this again was in November of 2016, correct?
Correct.
On page 9 of People's 206. That one first. Did the two of you continue talking about his relationship with his girlfriend?
Yes, we did.
And on page 9 of People's 206, did you say to him, well, you were a professional porn star and I lived the life of one?
Yes, I did.
And you asked him if she
Whoa.
knows, and he said it intrigues her.
Whoa. Whoa, I got to go back and see this face. He's whoa. That's the boyfriend? The professional home star? What?
On page 10 of these continuing Facebook messages, did you tell him she loves you
I
for
went
you
to the
and that's what
restroom.
matters?
My ears
Yes,
cut
I
out.
did.
And subsequent to that,
Is this the one that I'm alive?
Yes, she does. Cool with my crazy ass life. Plays R-ball too. What is R-ball?
Racquetball.
And then did you ask him how he met her?
Yes, I did.
Oh,
And on page 12, did he indicate
no, that's not him. I woke up for a minute.
that he met her at his gym and that she was on him,
Yes, he did.
trying to get at me and my dumb ass did even notice? LLOL.
He meant to say didn't even notice. Yeah.
And on the next page, page 13 of this exhibit, did you also ask if she makes money? And he responded, she's got a little money.
Yes.
And did you say to him, that's cool, it will stabilize you when you two move in?
Yes, I did.
On the following page, page 14, the last page of this exhibit, did Robert Baker tell you that he told his girlfriend about Tracy? That would be the wife, the ex-wife that you told us about?
Yes, that's correct.
And that his girlfriend told him to let it all go and that she will take care of all.
Yes.
She's like, I didn't know that.
Now, in February of 2017, did Robert Baker come to Las Vegas and meet up with you?
Yes, he did.
And did the two of you go out for sushi after playing racquetball?
No, we played basketball, and
Basketball.
when we met up, well, we used to always make fun of each other, and he had a Band-Aid in his hand, and I said to him, are you going to?
One moment, sir. Sustain.
When you played basketball, did you notice anything about his hands?
Yes, he had a Band-Aid in his hand.
And did you make fun of him for having a bandage on his hand?
Yes, I said, are you going to miss all your shots tonight because of that? And he said, I'm still going to kick your butt.
Was that the typical banter between the two of you?
Yeah, we're always teasing each other, laughing, joking. Yes.
Bantering.
And did he tell you who he was staying with when he came to Las Vegas at the beginning of, or sometime in February of 2017?
No, we didn't discuss.
Do you recall being interviewed by detectives who came to your home September 28th of 2017?
Yes, I do.
And did they speak with you and your wife at that point in time?
Yes, they did.
With respect to who Robert Baker was staying with, would it help to look at your transcript of that interview?
Sure.
48 and 114. Just read it to yourself. Looking at page
Oh.
48.
He
Just read it to
stayed-
yourself.
Well, birdsong.
Again, to yourself. So that means silently. Did you see that? And now I'm going to turn it to page 114 and read this to yourself. Does that refresh your recollection?
Yeah.
Okay. Do you remember who Robert Baker said he was staying with?
Al Birdsong?
Was that somebody that you subsequently met that last time that you saw Baker in Las Vegas with the defendant?
Yes, the first and only time I met him.
Thank you. When when you played basketball and had dinner with Baker in February of 2017, did you talk about his girlfriend?
Yes, we did. I asked him,
I just want to know if you had a conversation on that date.
yes,
Okay. And did you and Robert Baker meet up alone for dinner after playing basketball, or did your wife join in that one?
it was
on that
just,
occasion?
it was just Rob and I.
Now, at some point in March 23rd, the week between March 23rd and March 26th, did Robert Baker come to your home with his girlfriend?
Yes, he did.
And that was in Las Vegas.
Correct.
And when they came to your home, were they driving in a particular vehicle that you recall?
Yes, Rob drove and he was in a black, I think it was a Ford truck.
Like a Ford F-150
Yeah.
or like a Ford Expedition?
I think it was a Ford F-150
Like a pickup?
pickup truck. Yeah.
Thank you. And did he bring the defendant to your house,
Yes.
Monica?
That was the first time I met Monica.
Subsequent to going to your house, did you and the defendant and Robert and your wife Michelle all go somewhere for lunch?
Yes, we went to PF Chang's in Green Valley to have lunch.
One sunny day,
Is that the
the
first time
trial
you
is
had met his
noisy.
girlfriend?
Yes, that's the first time I met Monica.
And at some point during that lunch, did you ask Monica for her last name?
Yeah, Monica actually asked for my phone number. So then I said, hey, I put her number on my phone and I said, what's your last name? And she looked at me and she said, it's a long Italian, complicated last name. And she looked at Rob. They kind of spoke with their eyes. And then Rob said, just put down Baker. So even today on my phone, I have her as Monica Baker on my phone.
Did she ever correct him and give you that long Italian last name?
No.
And what did you and Robert Baker and Monica and your wife discuss during this lunch?
So Monica was going to buy a house in Vegas for Rob. And so I asked Monica if she was planning to move to Vegas. And she said, no, I'm just going to come and go. And we're going to travel to Italy and some other countries. And I'm going to buy this house for Rob. And then she asked me about stock market. I'm a stockbroker. So she was asking me how much money you can make in the market, what kind of things you can do. So we were discussing stock market and how to make investments and make money and things like that. And my wife's a realtor. So Monica was talking to her about potentially buying a house for Rob in Vegas.
So she told you that she was going to buy a house in Las Vegas where Rob would live and she would come and go from there?
That's correct.
And then she said that they were going to travel to Italy and other places. When you say she said they, who was she referring to?
Her and Rob.
I'm sorry. I'm sorry, I didn't hear. Is that what she told you? That she and Rob were going to be traveling to Italy and other countries?
Yes, she was talking about specifically about Rob and her traveling.
Did she say anything during this lunch about whether or not she, meaning the defendant, Monica Baker, had any property at that time?
Yes, she said she had a house in LA that she was going to sell and she was going to get proceeds from that. And it was apparently an expensive house.
Is that what she told you?
That's what she told us.
At any point during this first time that you met the defendant, either at your house or at the lunch with your wife at PF Chang's, did she ever mention to you that she had been married?
No, my wife and I had no idea Monica was married to anyone until the day the detective showed up at my house.
She never mentioned she had been married. Did she ever mention to you that she was a widow?
No.
When was the first time that you found out that the defendant had been married and widowed?
When
See, 1 second. Sustain.
That night after the lunch at PF Chang's in Green Valley, did you go out for dinner with Rob and Monica?
we planned to go out for dinner next night, the following night.
And the next night, where did the four of you go for dinner?
We went to this restaurant called Andrea's at Encore Casino, which is connected to Wynn, and it's a pretty high-end five-star restaurant. It was a high-end five-star restaurant, and Monica actually invited us.
Sustain.
And who who invited who to dinner? Did you make arrangements for the four of you to go to dinner, or was there an invitation? How is it the four of you, the two couples, wound up at dinner at Andrea's?
Monica invited us to dinner, and I arranged for the dinner through my contacts at Encore, at Andreas at Encore.
Oh. Set of photographs from March 25th through March 26th in Las Vegas. 7 pages in total. May this packet be marked as People's 207?
Yes.
Showing you People's 207. There's a 23 in the lower left corner. Do you recognize these photos?
Yes, I took these pictures.
And where were these photos taken?
It's at Andreas at Encore Casino.
And is this the night that you and your wife Michelle met the defendant and Rob for dinner?
That was the night we met for dinner, correct?
March 25th of 2017?
I believe so.
Showing you 207, the next page, there's 24, the lower right corner. Do you recognize what you see here?
Yes, I took that picture outside Intrigue nightclub.
And is that a location that you went to the following night on March 26th?
It was after dinner. After dinner at Andreas, we went to Intrigue nightclub, which is connected, Wynn is connected to Encore, so we just walked over there.
Okay. Showing you the following page of People's 207, there's a 25 in the lower left corner. Do you recognize what you see here?
Yes, that's on the stage, on VIP stage with the DJ at Intrigue nightclub.
Showing you exhibit 207. There's a 26 in the lower left corner. Do you recognize what you see here?
Yes, that's on the stage at Intrigue nightclub at the VIP section.
And 207, there's a 27 in the lower right corner, left corner. Do you recognize the individuals in this photograph?
Yes, it's my wife, Michelle, Monica, and Robert Baker. I took that picture.
Showing you 207, there's a 28 in the lower left corner. Do you recognize what you see here?
The picture with Michelle, Monica, and Robert, I took that, and the picture with me, Monica, and Robert, Michelle took that picture.
And 207, there's a 29 in the lower left corner, starting with the photograph on the left. Is that your wife with the defendant
That's my wife with Monica, correct?
at the nightclub?
That's correct.
And the photograph to the right?
That's up on stage with me on the left, my buddy who runs the club right in front of me, and then Monica and Michelle taking pictures of the crowd from behind the DJ.
Okay. Who paid for the dinner at Andrea's?
Monica did.
And what did she do or say in order to pick up the tab that night?
Well, Monica invited us to dinner, and then I kind of asked her if that's okay because the place is really expensive, and she was like, "Don't worry, I got money. It's mine. I got it." And then just order whatever you want.
That's overruled.
And then Michelle and I ordered little stuff, and we don't drink, so then we said, we don't want any drinks, and Monica said,
It is a narrative.
So after you told the defendant that you and Michelle don't drink, did the four of you abstain from drinking that night?
no, Monica was drinking. She ordered a bottle of wine, and she was drinking. And Robert and Michelle and I weren't drinking.
So she ordered a bottle of wine, even though you said you and Michelle weren't drinking.
She did.
I'm sorry. I didn't hear the objection. Sustain.
And what was her behavior like during that night at dinner at this restaurant?
So rule.
When I met Monica, she was the happiest person I've ever seen. She looked like she was a 22-year-old kid gone on spring break.
Sustain.
Can you tell us what her behavior was like that night?
Initially, you know, she was somewhat normal, and then as she started drinking, she started getting quite
Right. Tipsy much?
crude, sexual.
Ooh, here we go.
She was saying stuff to us
me
about
get
their
my-
sex life. She was grabbing his private parts in front of
Excuse me a
us.
second. It is not responsive.
When you said she was talking about their sex life and grabbing his private parts, whose private parts was she grabbing?
She was grabbing Rob's private part.
I'm
And
ready.
this was at the restaurant or at the nightclub?
Both, but at the restaurant, it was kind of embarrassing because people know us there, Michelle and I, and we were a little embarrassed.
Sustain.
And
I bet you were. I got to fix this.
did
Sorry, guys.
Rob seem like this was normal for him, or did he say anything to you?
No, Rob was upset.
First off, it's compound, and also speculation.
Did Rob say anything to you about her behavior that night?
Yes, we went
Where
to the
was that?
we went to the bathroom, Rob and I, and he apologized to me for Monica's behavior because he could tell Michelle and I were very uncomfortable with her acting kind of crazy, and I said it's okay. I said as long as you're happy, I'm okay.
Second, sir. It's not responsive.
Okay. Did you offer to pay for any of the bill, or who paid?
Monica paid, and it was a pretty big bill. So yeah, we were trying to be.
That's
I looked at the.
How much was the bill?
It was like close to $500.
I'm assuming that the bill included the wine, the bottle service?
Yes.
Okay.
That's a lot of alcohol, y'all.
When she was grabbing Rob's private parts, did she say anything?
She was telling us how great their sex life
Excuse me a
was.
second. Overruled.
I'm sorry?
Go ahead, you can answer.
We don't want to know
She
that.
was saying how great the sex life was and how great Rob was in bed, and I was making fun of him. I said, "How much did you pay her to say that?" And these kind of we were bantering back and forth.
Uncomfortable bantering.
So, when she was grabbing Rob's private parts, she was talking about how great he was in bed.
Correct.
It is cumulative.
I thought that you sustained the objections.
The objection as
So I
to the
react.
non-responsive parts.
Okay, so the rest of it remains. Yes,
That's
Your
true.
Honor? Thank you. At any point in time, did you see the defendant express any grief or sadness over the fact that her husband had been murdered approximately 2 months before?
First of all, we had no idea of that, and she didn't grieve even 1%.
Sustained. Answer the question.
He can say
Did
that.
she act in any manner as if she was
need to get a cord.
experiencing grief for her husband that had been murdered 2 months before?
Not even 1%.
I'm sorry,
I didn't rule the objection.
I didn't hear your answer.
Not even 1%.
We're going to take our adjournment this time till tomorrow at 9 o'clock. The admonition applies. You do not discuss this case either among yourselves or with anyone else with form or express their opinions. The cause is finally submitted to you. Have a good evening. See you tomorrow at 9.
Okay, I was going to replace a cord, but okay, we done. Wow, y'all. Wowza, wowza, wowza. Okay. It's been a long day. And I know everybody's going to go watch all these lawyers talk about what happened today. I'll be one of them. So I'm going to say farewell. Tomorrow, I have an 8:15 in the morning doctor's appointment. I should be back in time for this trial. So we will be back tomorrow with Simatilli. I will talk tomorrow. I like to think about things overnight, create my notes, then come back and talk tomorrow. So during break time, we'll be Karen Reed. During the Simatilli trial, will be Simatilli. and we will be back. Thank you guys so much for joining me. It's been a crazy beginning of a week. We'll see all of you tomorrow, and stay safe. Love on your loved ones, and remember, you're special. We'll see you then. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.